Good evening. Good afternoon. We are live. This is kind of an emergency thing here. So, yes, it appears there has been some news. The government has the Colorado Supreme Court has responded and issued an opinion in regards to what's going on with former President Trump and everything that's going on there. See if we could bring it up real quick. I want to read it and see see what it is, see what they got. So basically, the Colorado Supreme Court said that the insurrection ban has stopped him for now. But it's I don't know if you guys have seen that yet, but you guys can hear me. Yeah, all right. A Snide Armada says, "Why was he removed?" Because they made it appears the argument of the 14th Amendment insurrection issue was decided. So we've got this now, and we can take a look at it if you guys are interested. I think it's going to get into what's going on there. So it's pre-recorded. Okay. Yes. All right, here we go. I literally just saw this came out. This is like hot off the presses, guys. I've not had a chance to read it yet. So let's go ahead. So this is brand spanking new. All right, here we go. God, that is so crappy there. And we need to zoom out of here. So in this appeal, district court considering where Trump could do it, say a majority of the whole court holds that President Trump is disqualified from holding the office, Section 3 of the 14th Amendment of the United States Constitution. And that is the part of the 14th Amendment which talks about him being engaging in insurrection. And we will use, where is a good version of the 14th Amendment? Yeah, here we go. We'll pull that up in a second here, but they're saying that a majority of this court, and it's 4-3, there's 7 members of the Colorado Supreme Court, holding that President Trump is banned because of the insurrection ban. Let's see what this is going to ultimately do there. And they say because he's disqualified to be a wrongful actor on the election code, to list him as a candidate on the presidential primary ballot. So he's not on the presidential primary for Colorado. The court stays its ruling until January 4th, subject to any further appellate proceedings. So here's the actual opinion. Guys, it's 213 pages. I don't know how far we're going to get, but we're going to get through this, okay? Okay, yada, 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 everybody. Okay. Per curiam. Let's see, actually, here we'll bring up. Oh, wow. Okay, well, constitution.congress.gov went down. Everybody's using it. So let's try this. National Constitution Center. Okay. So here we have Section 3. No person shall be a senator, representative of Congress, or elector of president or vice president, or hold any office, or as an officer of the United States, if they shall have engaged in insurrection or rebellion against the same, or given any aid or comfort to the enemies thereof. But Congress can vote to remove the disability. Okay, well, that's never happening because he can't get 2/3 of Congress. But yes, the Colorado Supreme Court has determined that he shall has engaged. So that is Yeah. So, and begin, please. Okay, I'm sorry. I'm gonna try to make that bigger here. So this is the insurrection clause that they keep citing all the time. This is interesting. It is very interesting. So we're going to get into the actual thing here going in 1 second. I'm going to see who all is here so far. Wow, a lot of people. No pants, baby. How can he engage in insurrection with no conviction for it? I think they're going to explain that. We'll see. Brooks saying, are other courts going to lean on this? Probably. They'll use this as an example or as an excuse for them to do it. So let's get back to the opinion itself, though. Per curiam, and that's consistent with past practice and election-related cases with timelines. We issue this opinion per curiam. Okay, meaning they issue it from the court as a whole. They don't say who did what. So normally when you see per curiam, that means whoever, like, the court completely decided in complete agreement. This is being done, they're acting as a whole even if they don't agree. So let's get to, we want to skip to, here's the parts where they're going to start talking about what's going on. We affirm in part and reverse in part. Okay. The election code allows electors to challenge Trump's status under Section 3. Okay. Indeed, the election code provides electors their only viable means of litigating whether Trump is disqualified. Okay. Congress does not need to pass implementation legislation for Section 3's provision attach. Section 3 is self-executing, meaning it alone, if you've engaged in insurrection, you therefore are automatically done. So therefore, there's no further action need to be done. You are therefore disqualified and somebody needs to bring it up. Judicial review of Trump's eligibility is not precluded under judicial or the political question doctrine. We'll see what they talk about there. Section 3 encompasses the office of the presidency and someone who's taken an oath as president. On this point, the district court committed reversible error. So they're saying that Section 3 encompasses the office of the presidency and someone who has taken the oath as president. The district court did not abuse its discretion in admitting portions of the January 6th report and evidence. District court did not err in concluding that the events at the U.S. Capitol on January 6th were an insurrection. The court did not err in concluding that Trump engaged in that insurrection through his personal actions. Okay, yes, President Trump's speech inciting the crowd to apparently the peaceful part doesn't count when you don't want it to, was not protected by the First Amendment. The sum of these parts is this. Okay, that's nice. They boil it down. Trump is qualified from holding the office of the president under Section 3. Because he is disqualified, it would be a wrongful act under the election code for the secretary to list him as a candidate on the presidential primary ballot. We don't reach these conclusions lightly. Bullshit, you don't. Bullshit, you don't. We're mindful of the magnitude and the weight of questions before us. Yeah, sure you are. We're likewise mindful of our solemn duty to apply the law without fear or favor and without being swayed by public reaction. Okay. We're also cognizant we're in uncharted territory. Yeah. You are. But our resolution of this challenge on the election code, the secretary be required to include his name on the presidential ballot. Yes. Therefore, to maintain the status quo. Therefore, to maintain the status quo pending any review by the U.S. Supreme Court, we stay our ruling until January 4th, the day before the secretary's deadline to certify the content of the primary ballot. So that's why they're waiting, and that's why I thought they were going to tell us here. They're going to punt. They're punting and letting the Supreme Court decide for them. And then the state shall remain in place, and the secretary will continue to be required to include Trump's name on the ballot until SCOTUS makes its decision. So That'll be interesting to see what happens there. But that is the Colorado Supreme Court just punting. They didn't want to. We'll let someone else deal with this. We don't want to be the bad guys. Low watermark for $100. Do I hate low watermark for $100? Wow, it's nice seeing those red marks there. Thank you thank you so much. I appreciate that. Given what's going on here, your question is, do I hate Nick now? No, I do not hate him. No, I don't hate him. Colorado Supreme Court, yes. Nick Rekieta, no. But thank you, low watermark. To be fair, though, this is a very apropos name, given this is kind of a low watermark in democracy here. But access, how much did Ron DeSantis pay for this? Yeah. So let's keep going here. The background, we don't need the background part. Yeah, blah, blah, blah. That was so scary. It's an insurrection. Yeah. Okay. Oh, they want to cite the parts, walk down to the Capitol and show strength. Notice there's a lot of ellipses here. Fight like hell and would not have a country anymore. Okay, it's an insurrection. Oh no. The procedural history, we're going to skip that because we covered it. We watched what happened. So their analysis. We're now 15 of 213 pages in. So, oh boy, it's going to be a lot of reading. Whether the election code provides a base review, I'm not worried about the Colorado election code. I really don't care about it. It's the Section 3 stuff that matters, really. So, they consider Section 3 applies to a president. Okay. We address the admissibility of the January 6th report. Yeah, that's all garbage. All right. So, here we go. Okay. Let's see here. So Trump also listed a challenger on the election code under the traditional evidentiary standard of proof for issues arising under it. When a particularly important individual request, such as a constitutional rights issue, the proper standard requires more than a preponderance of evidence. As noted above, the electors proved their challenge by clear and convincing evidence. Did they really? They do point out, though, and this is very important, and because you didn't brief the issue, you've abandoned it. And that is a common appellate issue or appellate holding. You didn't bring it up, therefore you've waived it and you've abandoned it. So ultimately, though, is that really going to be the thing there? No. And I think maybe that's what him and his attorney decided. We're not going to raise this issue ultimately because, look, we know we're not going to win that one. And do I think it was clear and convincing it was an insurrection? No. I mean, I wish those people got hit harder, though. Or maced harder. Oh, it was so scary. It was so bad. I'm a big old policeman. It was so scary. We're going to have something to be scared of now. I can say that much. Reconstruction issued in the 14th Amendment and Section 3. A provision addressing what to do with those individuals who held positions of power before the war and fought on the side of the Confederacy and then sought to return to those positions. Yes. Okay, Section 3 provides, and we just talked about this here, interpreting it, our goal is to prevent the evasion of the provision's legitimate operation and effectuate the drafter's intent. Oh, so yes, we're trying to go to originalism here. To do so, we begin with its plain language, giving their terms their ordinary and popular meanings. Okay. The language is clear and unambiguous. We enforce it as written, and we don't need to turn to other tools of construction. However, if the language is reasonably susceptible of multiple interpretations, then it is ambiguous, and we must consider the textual, structural, and historical evidence put forward by the parties. Okay. So what is the evidence there? So the electors' claim is grounded here. They claim that they have the authority to do this. Based on there. Okay. The Trump and the, let's see here. They claim that because it's a constitutional claim, it can't be raised under state law. Okay. Um, before considering each of these arguments in turn, and that's the short of it. Trump and the Colorado Republican state committee have said that you can't use a constitutional just can't be resolved under state law. Generally, it makes sense. First, they explain that the interveners, they conclude the district court jurisdiction to adjudicate the elector's claim. Okay. But recognizing the ability to exercise jurisdiction does not mean the electors can state a proper claim. Okay. They explore whether states have the power to assess presidential qualifications. We conclude they do, provided their legislators have established such authority by statute. Analyzing relevant provisions, we then conclude the Colorado General Assembly gave Colorado courts the authority to assess presidential qualifications, and therefore the electors have stated a proper claim under the law. They address the related arguments, concluding that limiting the presidential primary ballot to constitutionally qualified candidates does not interfere with their rights under the First Amendment. Finally, they conclude that it provides sufficient due process for evaluating whether a candidate satisfies the qualifications for the office they seek. So they reviewed de novo, reviewing it completely. They're reviewing it as a whole. So what are they looking at here? Let's look at the presidential primaries on the election code. Actually, no, let's get to where I don't care about where do we get to the constitutional inquiry here? Let's see here. Because this is all, this right here, Colorado state law, I don't care. Yeah, the procedures for it in Colorado's law, I don't care about. Okay. District court has no jurisdiction. They're state court. I think they have jurisdiction. I don't care. Okay, yeah, here we go. States have the authority. This is the important stuff. States have the authority to assess presidential candidate qualifications. All right. Common sense says governments have the right to play an active role in structuring elections. Fair enough. I think they do. That makes sense. Real quick, another super chat. Stephen Cooper for $10. Thank you. Saying, as a Colorado citizen, I hate these bundles of sticks that have ruined my state. Yep, and I hate them now too, because they've ruined a lot more than just the state. So we need to keep going from here. Constitution delegates the state authority to prescribe the time, place, and manner of holding elections. States retain the power. The states exercise these powers through comprehensive and sometimes complex election codes. Yep. Regulating things here. These powers are uncontroversial and well explored in U.S. Supreme Court case law, and they generally are. Does the Constitution authorize states to assess the qualifications of presidential candidates? We conclude that it does. Under Article 2, Section 1, each state is authorized to appoint a presidential electors in such manner as a legislator there may have direct. And that's true. Each state determines how they pick their presidential electors. It's entirely, they can do it however they want. So long as the state's exercise does not run afoul of another constitutional constraint, that power is plenary, meaning it is not to be disturbed. It's basically unlimited in that scope. So as long as they don't interfere with other constitutional provisions, a state is free to exercise the power it sees fit to choose its electors. But voters no longer choose between slates of electors on election day. And that's true. We don't do this anymore. Instead, they vote for presidential candidates who serve as proxies for their pledged electors. Remember when we were dealing with the election, people were worried about like the faithless electors. That was a big thing in 2016. And then it became a thing in 2020 as well. So states have their plenary power to not only regulate the electors themselves, but also to regulate candidates' access to presidential ballots. Absent a separate constitutional constraint, then states may exercise their plenary appointment to limit presidential access to those candidates who are constitutionally qualified to hold the office of the president. And nothing in the Constitution expressly precludes states from limiting access to the presidential ballot to such candidates. No party in the case has challenged the Secretary of State their authority to require a presidential primary candidate to confirm on the required statement of intent form they meet the Article 2 requirements of age, residency, citizenship, and to further attest that he or she meets all the qualifications for office prescribed by law. Moreover, several courts have expressly upheld states' ability to exclude constitutionally ineligible candidates from the presidential ballots. The California's refusal to place a 27-year-old candidate on the ballot. The Secretary, this is another Secretary of State's decision to exclude a naturalized citizen from the presidential ballot. And that's because being a naturalized citizen does not allow you to be on the ballot. This is from the Northern District of Illinois. So that had been the Illinois Secretary of State. And then there's also, 10th Circuit would have been Colorado for Hassan. Sorry. And then Illinois affirmed their exclusion of a 31-year-old candidate from the presidential ballot. And that's because you have to be 35. They go to what Gorsuch cited in Hassan, that it's a state's legitimate interest in protecting the integrity and practical function of the political process that permits it to exclude from the ballot candidates who are constitutionally prohibited from assuming office. The question is whether Colorado exercises power through the code. We conclude it has. The Colorado state law is the vehicle for doing that. Okay, here we go. That part here talking about the law, I'm not necessarily worried about. It's Trump's electors cannot be properly litigated because this court's precedent bars litigation of constitutional claims. And they say, although we agree the secretary has no duty to independently investigate the qualifications of a primary candidate, we conclude the electors may nevertheless challenge a candidate's qualifications, under state law, and that the electors' claim here is not a constitutional claim as precluded. They're claiming they're challenging under state law, and they're going back up to, well, we have the right to choose our electors, so this is being challenged solely under state law. It may have constitutional implications, but we're doing it under state law. I know some of you out there may say that's a difference without a distinction, but that's the argument they're making here. So, Hot Coffee Chat says, could Trump appeal this? Yes, he can go to the Supreme Court of the United States. And certainly he's going to. I don't think he's going to go like, yeah, I'm out. So, it certainly can happen. Mr. Squiggle says for $5, let's say he's removed from the ballot. Can they write his name anyway in protest? Sure, it's a protest vote, but you can't write him in. If he's not a qualified candidate, you can't be written in. So, for example, if the person was 25 years old and you wanted to write them in on the ballot, you can't write them in you can write them in, but it's an invalid vote. So, yeah, it doesn't matter. John Adams for $5. Thank you. Saying Denver and Boulder control the state. The rest of us are pissed about it. Certainly. You certainly very likely are. Thank you for the super chat. Tridio for $5. Thank you. Is saying turnabout is fair play, right? If Texas, Oklahoma, Arkansas, Kansas, Missouri, Louisiana, Mississippi, Alabama, and Florida remove all Dems from their ballots ad infinitum, it's okay, right? Well, you'd have to show under what cause they're now prohibited. So you would have to, use Article 3. Section 3 of Article 14. You would have to use appropriate state law. So yes, if you could remove them, merely just peeling them off the ballot would not work, and that would be very, very bad to do anyway. But yeah, if there's grounds to go after them, yeah, sure, go after them. It's fair game. But just merely, just taking getting out the eraser and just, it not going to work like that. But I understand what you're asking here, I think. Thank you, though. It's a good question. And KJAB for $4.99 says, how do you think SCOTUS will respond? I don't know yet, because we'll have to see. I mean, if you want to say, oh, well, the ones that Trump appointed and the conservative side will side with Trump, well, then it's going to be 5-4 or 6-3. But who knows? Who knows at this point? We don't really know. So let's get back to it. So they say that the secretary's duty, once again, the Secretary of State, is to certify the names and party affiliations of the candidates to be placed on the primary ballots. The conditions must be satisfied. They confirm that they are a bona fide candidate under the party's rules, the notarized statement of intent, and the requisite filing fees or petitions signed by 5,000 eligible voters. When a candidate does not submit or cannot comply with the required attestations on the form of intent, the secretary cannot list the candidate on the ballot. So, the secretary has no. They're basically saying the secretary has no duty to investigate, and it's not their sole duty anyway. The accuracy or validity information that has been supplied. To the extent they agree with the president's secretary has no duty to determine beyond what is apparent, and they're saying that it's not the secretary's job to go investigate it. We agree, but that doesn't mean the Supreme Court of Colorado is saying that doesn't mean individual citizens can't challenge it though on their own, and that's what happened here. So, and this is where they get to it. Any challenge to the listing of any candidate on the primary election ballot is possible. And then Section 1-1-113(1) creates a cause of action for the electors alleging a breach of duty for other wrongful acts under the code. So they do have options to do this, and they do have vehicles, and they're arguing that vehicles have allowed it. And they say, as we explained, the secretary has complied with their limited duty to accept Trump's properly completed paperwork. But the electors have alleged an impending wrongful act, which is more expansive than a breach or a neglect of duty. And they point out that the state law challenges a broad range of wrongful acts committed by officials charged with duties under the code, including Inc. Act, which is inconsistent with the election code. They conclude certifying an unqualified candidate constitutes a wrongful act and runs afoul of state law. And they say nothing here prevents that from happening. And clearly, this limits participation in the presidential primary to political parties having fielded qualified candidates. They go on to say here that although Section 1-4-1203 does not define qualified, nearby provisions regarding writing candidates indicate that qualified refers to a candidate's qualifications for office. So here you go. I think Squiggles, you were asking us about the writing candidates. You still have to be qualified. So you still have to meet all the requirements. I'm 38, so you could write me in for being on the ballot, for president. Okay, because I meet all the requirements. But if you took a 15-year-old or a 21-year-old or a 31-year-old, they don't qualify. So that's where they're getting it. You still have to qualify. As with bona fide major party candidates, writing candidates for the presidential primary must file they must file a notarized statement of intent. Okay. Under the election code, such written statements for all candidates must include that the candidate desires the office and is qualified to assume its duties if elected. So they go on to further talk about writing candidates real quick there. Regarding the election code as a whole, then, we conclude that qualified in Section 1-4-1203 must mean at minimum a candidate is qualified under the U.S. Constitution to assume the duties of president. It has to, as supplies the only textual basis in the election code for the Secretary of State's authority to require a primary candidate to attest his or her qualifications. Okay, let's just keep going here. We conclude that under the election code, qualified candidates for the primary include are those who are qualified to hold office under the U.S. Constitution. Okay. They recognize, and this is, we recognize the Supreme Court has denied twice whether Section 3, which disqualifies an oath-breaking insurrectionist from holding office, amounts to a qualification for office. This is one from 1969. Describing Section 3 and similar disqualification provisions in the federal Constitution, but declining to address whether such provisions constitute qualifications for office because both sides agreed that the candidate was not ineligible under Section 3 or any similar provision. Okay. Then there was also U.S. term limits incorporated versus Thornton, seeing no need to resolve the same question. And that's why they didn't answer it, because if both sides agree it's not a problem, then the court's not going to rule on it, because that's not how the court rules. The court only rules on issues in dispute. And then this other one here, seeing no need to resolve the same question regarding Section 3 in a case concerning the propriety of additional qualifications for office. Okay. But they're saying, but lower courts, when presented squarely with this question, have all but concluded Section 3 is a functional equivalent of a qualification for office. They're saying out of the Northern District of Georgia. Okay. Where else do they have here? They have the New Mexico District Court. Okay. They're saying Section 3 imposes a qualification much like an age or residency requirement. So the Colorado Supreme Court had to go outside of Colorado to find things that backed up its claim. Doesn't mean it's a weak claim, but it's just, for them, it was their first impression at this point. Salty Ball says, so tonight on Timcast, Civil War. Yes. Very much. So civil, very war. Pepsi Man for $2. Thank you. Is saying, let my nigga Trump on the ballot. Thank you. So, all right, let's keep going here. Let's see what we got. We perceive no logical distinction between a disqualification from office and a qualification to assume office, at least for the purposes of the state law claim. Either way, it'd be wrongful act for the secretary to list a candidate on the ballot who's not qualified to assume the duties of office. Moreover, because Section 3 is a part of the text of the Constitution, assessing a candidate's compliance with it for purposes of determining their eligibility for office does not improperly add qualifications to those that appear in the Constitution. Okay, that part's fair enough. That part's not fair. I get, nothing to argue with there. So doing so merely renders the list of qualifications more complete. Okay, fair enough. Now we are persuaded by President Trump's assertion that Section 3 does not bar him from running or being elected because Section 3 only bars individuals from holding office. Hassan specifically rejected any such distinction. There, the candidate argued that even if Article 2 properly holds him ineligible to the office, Colorado could not deny him the place on the ballot. Well, the court concluded otherwise. The provisions of the election code governing primaries do not recognize such a distinction. Rather, those provisions require all primary candidates to be constitutionally qualified before their names are added to the primary ballot pursuant to state law. Okay. Their argument is that were we to adopt President Trump's view, Colorado could not exclude from the ballot even candidates who plainly do not satisfy the age, residency, and citizenship requirements of the Presidential Qualifications Clause of Article 2. It would mean the state would be powerless to exclude a 28-year-old, a non-resident of the United States, or even a foreign national from the primary ballot in Colorado. Yet, as noted, several courts have upheld the state's exclusion from the ballots people who fail to meet the qualifications under Article 2. Lastly, they reject the claim that state courts may not hear the elector's claim because this court's precedent bars litigation of constitutional claims under state law in the state law action. The electors have not asserted a constitutional claim, so therefore it doesn't apply. Once again, I know some of you might say that's a difference, a distinction without a difference, but that's the argument they're making. So that is what they're doing. Let's keep going. So they talk about, they're claiming the electors do not challenge the constitutionality of the election code, nor allege a violation of the Constitution. The electors claim has constitutional implications or requires interpretation of a provision does not make it a separate constitutional claim as other state law and case law issues have determined. So, there is that's where they make that argument here. Let's keep going here and a little further down. Okay, no, I don't care about that. I don't care about your state law crap. Okay, here we go. The electors challenge Secretary of State's ability to certify Trump as a qualified candidate, presumes that Section 3 is self-executing in the sense that it is enforceable as a constitutional disqualification without implementing legislation from Congress. Because Congress has not authorized state courts to enforce Section 3, the interveners, meaning Trump, argue this court may not consider Trump's alleged disqualification under Section 3 in this section with the proceedings, and they disagree. So, they claim, and this footnote here, the interveners and the supporting amici occasionally assert the electors' claim is brought pursuant to Section 3, and the section is not self-executing. In the sense, it does not create an independent private right of action. Yes, that is a claim. But as mentioned above, the electors do not bring any claim directly under Section 3. Their claim is brought under Colorado's election code, and resolution of that claim requires an examination of its qualifications in light of Section 3. So that's the argument. That's how they're getting it in, that they're not doing this under Section 3. They're doing it under state law, and the state law implicates Section 3. So the only mention of congressional power in Section 3 is that Congress may, by 2/3 vote of each house, remove the disqualification of a former officer who engaged in insurrection. Section 3 does not determine who decides whether the disqualification is attached in the first place. No, but someone has to. Someone still has to make that decision that it's attached. So it's not, and I don't think it's that easy. So, chances, Branko, why didn't you stop them? Jeez. So let's keep going, though. Interveners, however, look to Section 5 of the 14th Amendment, which provides that Congress shall have the power to enforce by appropriate legislation the provisions of this article, to argue that congressional authorization is necessary for any enforcement of Section 3. This argument does not withstand scrutiny. Okay. Why will this not let me write back in there? Oh, there we go. Okay. So, the Supreme Court has said the 14th Amendment is undoubtedly self-executing without any ancillary legislation so far as its terms are applicable to any existing state of circumstances. In the civil rights cases in 1883. To be sure, in the civil rights cases, this court was directly focused on the 13th Amendment, so this could be described as dicta. But an examination of the 13th, 14th, and 15th Amendments, the Reconstruction Amendments passed in the aftermath of the Civil War, an interpretation of them supports the accuracy and broader significance of the statement. Section 3 is one of the 4 substantive sections of the 14th Amendment. There's Section 1, which is no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. Privilege and immunities, you could say that's like a clause. So it's the privilege and immunities clause. Representatives shall be apportioned among the several states according to their representative numbers, counting the whole number of persons in each state. Yeah. This is no longer, the 3/5 of a person. Each person is a person. And then we get to section 3. This is the one we're focused on. Then section 4 says the validity of the public debt of the United States shall not be questioned. Like, how can I not question it? Is it real? Is it all fake? Who took it out? Why are we paying on it? Those are all questions I have. I know that's not what it means. I just thought it'd be funny to say. Section 5 is then an enforcement provision that applies to each of these provisions. Let's look at section 5. So let's go to section 5. Congress shall have the power to enforce by appropriate legislation the provisions of this article. Now, it's saying Congress has the power, but it's not saying it has to use the power. And yet the Supreme Court has held that Section 1 is self-executing. Okay. So basically the point is, thus, while Congress may enact enforcement legislation pursuant to Section 5, congressional action is not required to give that effect to the provisions. Section 2 is moreover enacted to eliminate the constitutional compromise by which an enslaved person was counted as only 3/5 of a person for purposes of legislative apportionment. And they point out that one's self-executing because, they point out that that one was self-executing as soon as we passed it, it went into effect and has never been called into question. And in the reapportionment following passage of the 14th Amendment, Congress simply treated the change as having occurred. Yes. They also point out, similarly, Congress never passed enabling legislation to effectuate Section 4. Well, just because they didn't pass it doesn't mean they weren't okay with it. I mean, it's also the argument they're just stupid. I mean, they are government workers, so they could be stupid. Just saying that's not a very good argument, but it is an argument that does exist nonetheless. So there we go. The same is true for the 13th Amendment, which abolished slavery and involuntary servitude. Section 1 provides that neither slavery nor involuntary servitude shall exist within the United States. Yes, nothing else needs to happen. By the passage of that amendment, slavery ended immediately. There was nothing else. The legislation, by its own unaided force, abolished slavery. And it was undoubtedly self-executing without any ancillary legislation. Okay. Like the other Reconstruction amendments, the 15th Amendment, which established universal male suffrage, contains a substantive provision. The rights of United States citizens to vote shall not be denied or abridged or on account of race, color, or previous condition of servitude. Followed by an enforcement provision. Congress shall have the power to enforce this article by appropriate legislation. So they're saying with Section 1 of the 13th and 14th Amendments, they point out that the 15th Amendment is self-executing. Oh, gosh, excuse me. It's been a long day already. Holy cow. I don't know about you guys. Orgus Din says, I'm fixing the voot. Yes. Oh. So let's see here. Let's keep going here. The court goes on to point out there's no textual evidence that Congress intended Section 3 to be any different. They point out that if these required legislation to make them operative, Congress can nullify them by simply not passing and enacting legislation, which is true. If they're saying the 13th, 14th, and 15th Amendments need legislation to be effective, they just sit there and without anything done, it's like, well, it's an amendment and you have rights, but there's nothing to enforce it. And they point out that such a result would mean that slavery would remain legal. Black citizens will be counted as less than full citizens for reapportionment. And non-white male voters could be disenfranchised. And any individual who engaged in insurrection against the government would nonetheless be able to serve in the government regardless of whether 2/3 of Congress had lifted the disqualification. Surely that was not the drafters' intent. I'm sure the Colorado Supreme Court always cares about what the drafters' intent was. I'm sure of it. I'm entering Snorlax mode. Not yet. We're going strong still. We're still going strong. Hold on. I need to shut a fan off. It is making me cold. I'll be right back. There we go. All right, we're back. Let's keep going. The interveners argue certain evidence requires a different conclusion. We generally turn historical and otherwise extrinsic evidence only when it is ambiguous, which is not here. Nevertheless, we'll consider these historical claims in the interest of providing a thorough review. They talk about Thaddeus Stevens made during the framing debates. Section 3 will not execute itself, but as soon as it becomes a law, Congress in the next session will legislate to carry it out both in reference to the presidential and all other elections that we have the right to do. Okay. But as one of the amici points out, this statement referenced a deleted portion of Section 3 that disenfranchised all former Confederates until 1870. And they say, in any event, given the complex patchwork of prescriptives and intentions expressed when drafting these provisions, we refuse to cherry pick individual statements from extensive debates to ground our analysis. They also point out to the non-binding opinion written by Chief Justice Salmon Chase when he was writing circuit in re Griffin in Virginia. So known as Griffin's case. There, Caesar Griffin challenged, or Cesar, probably Caesar, challenges criminal conviction as null and void because under Section 3, the judge who had entered his conviction was disqualified from holding judicial office, having formally sworn a relevant oath as state legislator and then engaged in insurrection by continuing to serve as a legislator in Virginia's Confederate government. It was undisputed the judge fell within Section 3, but the Chief Justice sought to answer was whether Section 3 operated directly without any intermediate proceeding, whatever, upon all persons within the categories depriving them at once and absolutely of all official authority and power. So that is where we are. So Chief Justice Chase observed that after the end of the Civil War, but before the 14th Amendment was ratified, many southern states had established with the approval of the federal government provisional governments to keep society functioning, and they did. And with these provisional governments, many offices were filled with citizens. They were filled with citizens who would fall within Section 3 and their scope. The Chief Justice observed that giving Section 3 a literal construction, as Griffin advocated, would annul all official acts performed by these officers. Well, I mean, it's got a point. If we're doing this, we're all in or all out. Yeah, no sentence, no judgment, no decree, no official act would be of the least valid. Yeah, well, that's what you're trying to say. If you're saying Section 3 is a real thing, well, then it's a real thing, and let's do it. You know, everybody wants to talk about Section 3 until it's time to do Section 3 shit. Like, I think that's just not fair. That's a bit ridiculous, personally. He reasoned it would be impossible to measure the evils which such a construction would add to the calamities which have already fallen upon the people of these states. And they claim that, you know, the argument from inconveniences and the interpretive canon when faced with two or more reasonable interpretations, the interpretation is to be preferred which best harmonizes the amendment with general terms and spirits of the act amended. I'm trying to figure out what's the best way to resolve that. So that would be the rest of what Justice Chase talked about. Let's keep moving, though. We're going to make it through all 200 pages. We got to get through all of it. So hang tight, guys. And hold on one second. I am a little bit frozen up. All right. Let's see where people are talking. All right. Is it SCOTUS time? Yes, it's going there. Operation Sleepy Weasel. Jeez. Chaucerian Fraud says, I would like to own a cannon. Yes. Is the Second Amendment self-executing? You'd like to think so, but apparently not. Bernie says, I'd like an F-22 Raptor. Well, it depends. Is it self-executing? I mean, it doesn't say so. So we will... Orgus Din says, Null shout-out. Yes, to Null and the farms. I know times are tough. Rebellion against Liz Dong Jones, Cogent, and Hurricane Electric, but, you know, the farms always comes out on top. So my yawning is quit yawning. Well, I'm trying not to. Get a Red Bull and a White Claw. Let's get deep in this. You know what? I'm gonna grab a White Claw. We're gonna get going. Hold on here. I'm gonna go grab one because we need one. So hold on. We're gonna do that real quick. What do I got we can watch for a second here? Yeah. Here we go.
Man! Check him out, y'all. He having the time of his life.
I understand. I'm just saying I'm not falling asleep, I promise. All right. Cannon says you're all... Yeah, we're all anarchists here. Sorry, guys, I didn't realize we were muted. So they do point out that Trump. Okay, we're back. Sorry, guys. Acting like the perfect woman right now. Thank you. So they point out that their final one of the arguments Trump put forward, they're not persuaded by, which is 18 U.S.C. 2383, which says makes it a crime to engage in rebellion. And they say, true, with that enactment, Congress criminalized a conduct. All that means, however, if you're charged and convicted under it, which actually I don't think that means if you're charged, I think you have to be convicted. Being charged isn't enough. You'd be disqualified under Section 3. It cannot read to mean that only those charged and convicted of violating the law are constitutionally disqualified from holding office without assuming a great deal of meaning not present in the text of the law. And that also, that's an argument I think goes back to the argument whether or not it's self-executing. So they're claiming that based on the decisions regarding the other Reconstruction Amendment self-executing and the absurd results that would flow from the readings that Trump wants to include, they conclude Section 3 is self-executing in the sense that its disqualification provision attaches without congressional action. Their contrary arguments do not persuade us otherwise. Okay. That said, our conclusion that implementing legislation from Congress is unnecessary for us to proceed under state law does not resolve the question of whether doing so would violate separation of powers among the three branches of government. So that's the issues of federalism, the separation of powers, whether or not it's justiciable. So the justiciability, that's a big word. You can use it. You can use it at the Christmas dinner table. Justiciability, justiciability, big word, big word. That's a $10 word right there. President Trump then asserts that the disqualification presents a non-justiciable political question, meaning the court can't touch it. Again, we disagree. Well, yes, I'm getting the hint that a lot of things is disagreement based on. In general, the courts have a responsibility to decide cases properly before it, even those it would gladly avoid. The political question doctrine is a narrow exception to the rule, and a court may not avoid its responsibility to decide a case merely because it may have political implications, except it does that a lot. Happens a lot of times. A controversy involves a non-justiciable political question. When it's relevant here, there's textually demonstrable constitutional commitment to the issue, to a coordinate political department, or a lack of judicially discoverable and manageable standards for resolving it. And they go further to point out that in Baker v. Carr, which that's in it, case is really good there. It's actually a good one to read. The non-justiciability of a political question is primarily a function of the separation of powers, and identifying the above described instances and 4 others not relevant here as examples of political questions. The requisite textual commitment must be prominent on the surface of any case. So they're saying it must be pretty much here on the top. The argument that Trump is raising is that the Constitution and federal law commit the question and the qualifications to Congress. The electors point out that the president did not argue before us that the questions presented in this appeal are also non-justiciable based on a lack of judicially discoverable and manageable standards, and therefore he arguably waives such argument. They nevertheless address an issue. Well, this, once again, Trump picks shitty attorneys. That's all he does. I pick the best, and he picks shitty fucking attorneys all the time. That's all he does. Just awful attorneys. Come on, Donnie. You got to pick better attorneys, man. No textually demonstrable constitutional commitment to Congress of Section 3 disqualification. Okay. So let's see what we've got. Contrary to Trump's assertions, we perceive no constitutional provision that reflects a textually demonstrable commitment to Congress of the authority to assess presidential candidate qualifications. Conversely, the Constitution commits certain authority concerning presidential elections to the states and in no way precludes the states from exercising that authority to assess the qualification of presidential candidates. We already talked about that a little bit as well. States can pick the electors. They get to decide how they pick the electors. So it's not actually there. So let's see, 3 more. Who's on here? So, all right. Wait, who is texting me? What the heck? Why is my phone buzzing like crazy? As discussed in Part B4 above, Article 1, Section 2, and okay, great. They reference exactly what I was going to say. How to talks about how the presidential electors are picked and appointed. Yep, and they recognize that states have far-reaching authority over electors absent some other constitutional constraint. Okay, yeah, the election code, once again, I don't care about that. We need to keep moving here. I want to get to and this is actually here where they make the justiciability argument. And this actually looks like it makes, they're at least making it in a way that makes some sense. They're saying under Article 2, Section 1, Clause 5, no person shall be eligible to serve as president unless that person is a natural-born citizen who's at least 35 years old and has resided in the United States for at least 14 years. This provision, however, says nothing about who or which branch should determine whether a candidate satisfies a qualification criteria, either in the first instance or when a candidate's qualifications are challenged. The 12th Amendment charges the Electoral College with the task of selecting a candidate for president and then transmitting the electors' votes to the seat of the government of the United States. And it provides a procedure by which the electoral votes are to be counted. Nothing in the 12th Amendment, however, vests the Electoral College with the power to determine the eligibility of a presidential candidate. Nor does the 12th Amendment give Congress control over the process by which the president and the vice president are normally chosen, other than the very limited one of determining the day on which the electors were to give their votes. They say, although the 12th Amendment provides for the scenario in which no president is selected by March 4th and specifies that no person constitutionally ineligible to serve as president shall be eligible to serve as vice president, the amendment does not assign Congress, nor to any other branch, the task of determining whether a candidate is qualified in the first place. So that is how they make their argument there. And that's what they do. They go on to talk about Section 5 authorizing Congress to pass legislation to enforce the 14th Amendment. But as they already said above, they've already determined it's self-executing in all parts, and the action is not required. Nor does Section 5 delegate to Congress the authority to determine the qualifications of the presidential candidates to hold office. Finally, the 20th Amendment, in relevant part, empowers Congress to enact procedures to address a scenario in which neither the president nor the vice president qualifies for office before the time fixed for the beginning of their terms. By its express language, however, this amendment applies post-election, referring to the presidential-elect and vice president-elect. Moreover, the amendment says nothing about who determines in the first instance whether the president and vice president are qualified to hold office. So for these reasons, they perceive no textually demonstrable constitutional commitment to Congress of the authority to assess presidential candidates' qualifications, and neither President Trump nor his amici identify any constitutional provision making such a commitment. Reach this conclusion, we're unpersuaded by cases in which Trump and his amici rely, which are predicated on inferences they assert can be drawn from one or more of the foregoing constitutional provisions or the fact that cases have political implications. And then these are all cases that are, obviously, like, look, Democratic Party, Mississippi versus Electoral College versus Obama. All kinds of cases here, Board of Elections. And they point out that these cases all here support that claim. So that's why it's saying C. In legal citations, this means see these cases, they back up exactly what we're saying. And they found cases all over the country to do that. As noted above, such inferences are insufficient to establish the requisite clear contextual commitment to a coordinate branch of government. And we may not avoid our duty to cite a case merely because it may have political implications. Yes, but you know how many times that does happen? A lot. Let's be real. They also will say we're not going to conflate actions that are textually committed to a coordinate political branch with actions that are textually authorized. They point out Supreme Court has only prohibited courts from adjudicating on the former, not the latter. Absent affirmative constitutional commitment, we cannot abdicate our responsibility to reach a case that is properly before us. And they think it's properly before them, so there is no political question. We'll keep going here because I think they've already established that they are going to find, and I'm going to skip through the political question part because I want to see their determination. Here we go. This is what I want to see. The district court concluded that the presidency is not an office, civil, or military under the United States for two reasons. First, to note the president is not specifically mentioned in Section 3, which kind of a big deal. The court found it unlikely the presidency would be included in a catch-all of any office, civil, or military. The second, the court found it compelling, and this is the trial court, found it compelling that an earlier draft of the section specifically included the presidency. So an earlier draft did include it, but then they intended to omit it later. And yeah, you're looking through what was passed, what was proposed, and what was passed. They disagree with that conclusion as a reading of both the constitutional text and historical record counsel that the presidency is an office under the United States within the meaning of Section 3. They point out that we prefer a phrase as normal and ordinary usage over secret or technical meanings that would not have been known to ordinary citizens in its founding generation. And they cite Heller. That's there we go. Dictionaries from the time of the 14th Amendment's ratification define office as a particular duty, charge, or trust conferred by public authority and for a public purpose that is undertaken by authority from government or those who administer it. When they go through, they also find, yes, a public, and that's how you spell public, charge or employment, magistracy. And it goes back to the Roman concept of being a magistrate, the magistratum. Magistrates had a lot of power back in the times of the Romans. They also go to a 1823 case that says an office is defined to be a public charge or employment. They say the presidency falls comfortably within these definitions. We do not place the same weight on the district court on the fact that the presidency is not specifically mentioned in Section 3. It seems most likely the presidency, I love this, well, we're focusing on the text, but it seems most likely it's not there because it is so evidently an office. They do point out, though, in fact, no specific office is listed in Section 3. Instead, it refers to any office, civil or military. So, they point out that senators, representatives, and presidential electors are listed, but none of these positions is considered an office in the Constitution. Instead, senators and representatives are referred to as members of their respective bodies. And they point out that each house will be the judge of the elections, returns, and qualifications of its own members. So, members. They point out no person holding any office in the United States shall be a member of either house during his continuance in office, meaning you can't be a member of the House or Senate if you you can't be any office in the United States if you are also a senator or a congressman. You can only be one. So, see where we are here. Yes, I said member a lot. So, indeed, even interveners do not deny the presidency is an office. Instead, they assert that it's not an office under the United States. Their claim is that the president and elected members of Congress are the government of the United States and therefore cannot be serving under the United States. We cannot accept this interpretation. A conclusion that the presidency is something other than an office under the United States is fundamentally at odds with the idea that all government officials, including the president, serve we the people. Well, they don't do a very good job of serving we the people. They act like they don't, regardless of who's in office. A more plausible reading, so now they're guessing, they're musing. They actually don't know. A more plausible reading, and we think the phrase under the United States is that the drafters meant to simply distinguish those holding federal office from those held under any state. You know what? That's fine, that's plausible, but I thought we were relying on the text. Just thought. This reading of the language of Section 3, moreover, is most consistent with the Constitution as a whole. The Constitution refers to the presidency as an office 25 times. Yes, I'm wondering if they would, never mind, I'm not going to say it. That would be, the Senate shall choose, and sick means that's spelled wrong, but they're acknowledging it's the way they came across it. There are other officers and also president pro tempore in the absence of the vice president, when he or she shall exercise the office of the president in the United States. They point out that no person should be eligible for the office of president, natural born citizen. The executive power shall be vested in the president of the United States of America, who shall hold his office during the term of 4 years. In several contexts, they clearly support that the Constitution determines it is an office. Consider, for example, the impeachment clause. It reads that Congress can impose as a consequence of impeachment a disqualification to hold and enjoy any office of honor, trust, profit under the United States. If the presidency is not an office under the United States, then anyone impeached, including a president, could nonetheless go on to serve as president. This reading is nonsensical, as recent impeachments demonstrate. The articles of impeachment brought forth against President Clinton and Trump asked for each man's removal from office and disqualification to hold and enjoy from any office, trust, or profit under the United States. Sure, heat this when it recalibrates. Sure, the impeaching members of Congress correctly understood that if either man, if convicted, subsequently was disqualified from future federal office by the Senate, would be unable to hold the presidency in the future. Similarly, the Incompatibility Clause states that no person holding any office under the United States shall be a member of either house during his continuance in office. To read office under the United States to exclude the presidency would mean that a sitting president could also constitutionally occupy a seat in Congress, a result foreclosed by basic principles of the separation of powers. Well, are you using the fact there's separation of powers to show that wouldn't work? Or are you using it to show that the language right there would work? Like you're kind of setting that through a different. They were making the points here. This one is not as strong as a point. I think that probably could have been worded better. I don't think they worded that properly. The further concern of the framers of the Constitution with maintenance of the separation of powers is found in the so-called ineligibility and incompatibility clauses in Article 1, Section 6. So, finally, the emoluments clause provides that no person holding any office of profit or trust in the U.S. shall, without the consent of the Congress, accept any president, monument, office, or title of any kind, whatever, from any king, prince, or foreign state. To read the presidency as something other than an office under the United States would exempt the nation's chief diplomat from these protections against foreign influence. We had to go there. Presidents have long sought dispensation from Congress for taking gifts from foreign leaders. Understanding the emoluments clause required them to do so. The district court brought up the earlier draft of the proposed section listing the presidency. They point out that it's always perilous to derive the meaning of an adopted provision from another provision deleted in the drafting process. And they once again cite Heller. And the specifics of the change from the earlier draft to what was ultimately passed do not demonstrate an intent to exclude the presidency from the covered offices. The draft proposal provided the insurrectionist oath breakers could not hold the office of the president or vice president of the United States, senator, or representative in the National Congress, or any office now held under appointment from the President of the United States and requiring confirmation of the Senate. So that includes any cabinet positions, undersecretary positions as well. Later versions of the section, including the enacted draft, removed a specific reference to the President and Vice President and expanded the category of office holder to include any office, civil or military, rather than only those offices requiring presidential appointment and Senate confirmation. It is hard to glean from the limited available evidence what the changes across proposals meant. And that's true. It's hard to work on that. There was a change, but that's all they've got. So, let's keep going here. We're going to keep going. I was checking the comments real quick. We find persuasive amici suggestion that Representative McKee, who drafted these proposals, most likely took for granted that his second proposal included the president. So we got to look at the text. What the text says, it says, well, no, but we can say the guy who drafted this, well, we're pretty sure he meant somebody. Oh, we agree. Yeah, he pretty sure meant this. According to who? Well, we think so. Yes, we can't infer stuff until we want to infer stuff. Brilliant. 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 I mean, really. They point out that while nothing in his public speeches mentions why the express reference to the presidency was removed, his public pronouncements leave no doubt. That a subsequent draft proposal still sought to ensure the rebels had absolutely no access to political power. Representative McKee explained that under the proposed amendment, the loyal alone shall rule the country, and that traitors would be cut off from all political power in the nation. And it's funny though, because this is, and I think Robert Barnes, and I forget who was pointing this out too, this whole idea of 14th Amendment Section 3 scholarship has only come out since 2021. In 2020. Why am I'm an established scholar on this? Citing something that, yes, the forgotten goals of constitutional reform. Yes, a guy who wrote Punish Treason, Reward Loyalty. The forgotten goals of constitutional reform after the Civil War. Like, my brother in Christ, come on now. Like, this is... This is just fucking nonsense. Punish treason, reward loyalty to forgotten goals of reform in 2023. Are you serious right now? It's all brand new. All brand new. All brand new. The desire to exclude all oath-breaking insurrectionists from all federal offices, including the presidency. When considering light of these, the shift from specifically naming the president and vice president, in addition to officers appointed and confirmed to the broadly inclusive, any officer, civil or military, cannot be read to mean the two highest offices in the government are excluded from the mandate of Section 3. Are you sure about that? So, yeah, this is... So, let's keep going. The importance of the inclusive language, any officer, civil or military, was the subject of a colloquy in the debates surrounding the 14th Amendment. Senator Reverdy, I guess, worried that the final version of Section 3 did not include the office of the presidency. He stated this amendment does not go far enough because past rebels may be elected president or vice president of the United States. So he asked, why did you omit to exclude them? I do not understand them to be excluded from the president, the privilege of holding the two highest offices, and the gift of the nation. Senator Lott Morrill fielded the objection, and he replied, let me call the senator's attention to the words, hold any officer, civil or military, under the United States. This answer satisfied him and said, perhaps I am wrong as the exclusion from the presidency. No doubt I am. But I was misled by noticing the specific exclusion in the case of senators and representatives. Well, is it saying he's saying perhaps I'm wrong? He's not saying, oh, yeah, my bad. He's saying perhaps I'm wrong. And he's saying, but I was misled by the way this is presented. Well, I mean, now we're reading into things, I guess. This colloquy further supports a view that the drafters of this amendment intended the phrase any office to be broadly inclusive and certainly to include the presidency. Okay. Moreover, Reconstruction-era citizen supporters and opponents of Section 3 alike understood that Section 3 disqualified oath-breaking insurrectionists from holding the office of the president. The Montpelier Daily. Yes, from Montpelier, Vermont. Yes, so... yes, Reconstruction-era citizens in Vermont. I mean, how would citizens in Texas view this? I mean, we don't see that. We just see the Montpelier Daily. Yes, Montpelier. What about the Birmingham Daily? Or, well, the Atlanta one? Well, God, they're probably still smoldering. So probably not the Atlanta Journal-Constitution because it's probably still burning. But pick another place, and the Richmond paper because it didn't get burned. Sorry, Atlanta, I couldn't resist that joke. So many supporters of Section 3 defended the amendment on the ground that it would exclude Jefferson Davis from the presidency. And once again, we see this. A guy wrote an article, a law review article or something here. Insurrection, disqualification, and the presidency forthcoming in 2023 in its manuscript. This is that brand new insurrection. I'm an insurrection scholar. Let's not bullshit ourselves. Just stick your cap on the old stuff here to bring in brand new scholarly research that nobody's contested or checked. A bit much. I will say this one here though. This is actually compelling. It looks like they cite somebody from 1867. Saying, arguing that that foregoing Section 3 would render Jefferson Davis eligible to the presidency of the United States And there is something revolting in the very thought. Well, I'm sure rebels and federal. I'm sure Judge Gallipolis. Yeah, I'm sure he. Yes. No, notice it's still only people with northern sympathy. So, just saying. For example, Congress floated the idea of blanket amnesty to shield the rebels from Section 3. And once again, this is the guy who just wrote his thing that's not even published. In response, both supporters and dissenters acknowledged that doing so would allow the likes of Jefferson Davis to access the presidency. Well, he would have to win the North as well as the South, so I don't think he could. And the Pulaski Citizen, well, I don't know where that is. Acknowledging as a supporter of amnesty that would make even Jefferson Davis eligible again for the presidency. The Chicago Tribune of 1872, which once again, Chicago, certain amnesty would make the rebels eligible for presidency of the United States. And Indiana, similarly. So once again, where's Pulaski? Well, that's a lot of different places. There's like a Pulaski County all over the country. There's like one in Arkansas, but is that the same one we're talking about? I don't know. We conclude, therefore, the plain language of Section 3, which provides notice qualification under the United States, includes the office of the presidency. This textual interpretation is bolstered by the constitutional context and by history surrounding the enactment of the 14th Amendment. Okay. Okay. Oh. Damn, D-Day's got freaking 2.9K people. Seriously? Oh. Let's just keep going there. Pulaski is obviously from California, maybe. Yeah, Cringe Punish is D-Day Cobra. Yeah, he's got like 3,000 people. It's like, these. We're actually going through this here, but whatever. You guys are the refined, highly intelligent, sophisticated crowd. You actually want to read it and study the legal analysis here. Number 2, President is an officer of the United States. Okay, well, we consider President as an officer of the United States. The district court found the drafters that did not include the president with the catch-all phrase officer. We disagree for 4 reasons. First, the normal ordinary use to determine the officer of the United States includes the president. As we have explained, yeah, they're rehashing this, but they're explaining it a couple different ways. The plain meaning of officer under the United States includes the presidency that follows then the president as an officer of the United States. Okay. I mean, they're already reiterating what they've said, so it makes sense. They've already made their conclusion this would follow. Indeed, Americans have referred to the president as an officer from the days of the founding. Going back to the Federalists with Alexander Hamilton, the presidency would be an officer elected by the people. Many 19th century presidents were described or call themselves the chief executive officer of the United States. Once again, we have this guy with his insurrection. I'm an insurrection scholar. Second, Section 3's drafters and their contemporaries understood the president as an officer of the United States. Once again, these guys are their 2023 research. They refer to the president as the chief officer of the country. We have no officers in this government. The Floyd acceptances, and this is a Supreme Court case saying, we have no officers in this government from the president down to the most subordinate agent who does not hold office under the law with prescribed duties and limited authority. They're saying Trump concedes so much on appeal that, to be sure, the president is an officer. Okay. He argues, however, the presidency is an officer of the Constitution, not an officer of the United States. which he posits as a constitutional term of art. For at least one amicus contends that the above referenced historical uses refer to the president as an officer only in a colloquial sense, and they have no bearing on the term in Section 3. We disagree. Well, shocker. The informality of these excuses is exactly the point. And members of the 39th Congress and their contemporaries all use the term officer according to its ordinary meaning to refer to the president. We presume this is the same meaning the drafters intended to have in Section 3. We perceive no persuasive contemporary evidence demonstrating some other technical term of art meaning. And in the absence of clear intent to employ a technical definition for a common word, we will not do so. Only all the courts viewed Heller that way, but apparently we're only doing it that way when it suits them. So I'm sure they've upheld the Colorado Supreme Court's, the Colorado weapons bans. So, we also find Attorney General Stanbury's opinions on the meaning of Section 3 significant. In one opinion on the subject, Stanbury explained that the term officer of the United States within Section 3 is used in its most general sense and without any qualification as legislative, executive, or judicial. And in a second opinion on the topic, he observed that the term officers of the United States includes without limitation any person who has at any time prior to the rebellion held any office, civil or military, under the United States and has taken an oath to support the Constitution of the United States. So under his logic and under this definition, does that mean if I didn't hold an office prior to the rebellion, I led an insurrection, but I wasn't an elected official, I could then do this? I mean, that's I think you have to be careful about that, because is that really what you want to allow? Because I think that's very sloppy language there. Just saying there. I mean, like if Jefferson Davis had never been a member of the House of Representatives and then never been Secretary of War and then had never been a U.S. Senator, like how would that work? How would that work? Would he then be allowed to be eligible to run again? I think that's not necessarily the best way to word that. Third, the structure of Section 3 persuades us that the president is an officer of the United States. Okay. First half of Section 3 describes the officers protected, and the second half addresses the parties barred from holding those protected offices. There's a parallel structure between the two halves. Senator or representative of Congress represents the member of Congress. Any office under the United States is the protected part, corresponds to officer of the United States under the barring part. And any office under any state protected title has a corresponding barred part in member of any state legislature or as an executive or judicial officer of any state. The only term in the first half of Section 3 that has no corresponding officer or party in the second half is elector of president and vice president, which makes sense because elections do not take constitutionally mandated oaths, so they have no corresponding barred party. So they're saying save the electors. There's perfect corresponding parts of Section 3. I get what they're getting there. I get what they're getting at. Fourth, the clear purpose of Section 3 to ensure that disloyal officers can never again play a role in governing the country leaves no room to conclude that officer of the United States was used as a term of art. The drafters of Section 3 were motivated by a sense of betrayal, that is, by the existence of a broken oath, not the type of officer who broke it. All of us understand the meaning of the third section. It includes those men who have once taken an oath of office to support the Constitution of the United States and have violated that oath in spirit by taking up arms against the government of the U.S. and are to be deprived for a time of at least holding office. Deprived for a time? Well, deprived for a time. Why not forever? And then they go to a senator who agreed that the theory of Section 3 was that persons who have violated the oath support the Constitution ought not to be allowed to hold any office. But eventually some were, so apparently it didn't seem to be that way. Explain that the language of this section is so framed as to disenfranchise from the office leaders of any rebellion hereafter to come. They also cite a case here that those who have once been trusted to support the power of the United States and proved false ought not as a class to be entrusted with power again until Congress saw fit to relieve them from a disability. So they therefore conclude that officer of the United States includes president. Then they are saying, now they get to the oath part. And this is one of the arguments that Trump made. I support a different oath. I wasn't sure how this one was going to work, but this is one of the arguments you have to make. So here we go. Here we go. Finally, we consider whether or not the oath taken by the president to preserve, protect, and defend the Constitution is an oath to support the Constitution of the United States. The district court found that because the president's oath language is more particular than the oath referenced in Section 3, the drafters did not include the former presidents. We disagree. Again, big shock. Article 6 of the Constitution provides that all executive and judicial officers shall be bound by an oath or affirmation to support the Constitution. Article 2 specifies the president shall swear an oath to preserve, protect, and defend the Constitution. Article 2, Section 1, Clause 8. Interveners contend that because, and that means Trump, because Article 2's oath does not include a pledge to support the Constitution, an insurrectionist president cannot be disqualified from holding office under Section 3 on the basis of that oath. They point out this argument fails because the president is an executive officer of the United States under Article 6, albeit one for whom a more specific oath is prescribed. They point out that the senators and representatives before mentioned and members of the several state legislators and all executive and judicial officers, both the United States and of the several states, shall be bound by oath or affirmation to support the Constitution. Okay. This conclusion flows logically from the accepted fact the vice president is also an executive officer. True, the vice president takes a more general oath prescribed by federal law, noting that anyone except the president elected or appointed to an office of honor or profit in the civil service or uniformed services, they shall take an oath or pledge to support and defend the Constitution. And that's true. Like, they take a very general oath compared to the president's. They do point out that, and this is something, where did I see this? They mentioned. They point out that Article 5 does not have a specific oath in its own thing. But it makes no sense to conclude the vice president is an executive officer under Article 6, but the president is not. And that's a fair argument. The language of the presidential oath by a commitment to preserve, protect, and defend the Constitution is consistent with the plain meaning of the word support. Modern dictionaries. What about the dictionaries in the 1870s and 80s? Modern dictionaries. Now we're using modern dictionaries? Okay. Support to include defend and vice versa. I don't know why they went to the modern part. So do dictionaries from the time of Section 3's drafting. That's where if you spent all that time about what happened in 1860, well, let's stay in 1860. So it says support to stand in defense of, protect or support, to defend, to support or maintain. I don't understand why they went to the modern part here. This is completely unnecessary. This whole part right here is just, you could probably get rid of it. At least I would. Get rid of this part. And just, because you're focusing on, aren't we focusing on what happened back then? Well, focus on what happened back then. Just start with this part. This would make a lot more sense and flow with the argument you're trying to make. The specific language of the presidential oath does not make it anything other than a note to support the Constitution. Indeed, as one senator explained just a few years before Section 3's ratification, The language in the presidential oath of office that he shall protect, support, and defend the Constitution makes his obligation more emphatic and more obligatory if possible than ours, which is simply to support the Constitution. And in fact, several 19th century presidents referred to the presidential oath as an oath to support the Constitution. In sum, the simplest and most obvious interpretation of the Constitution is in itself sensible is most likely to be meant by the people in its adoption. The most obvious sensible reading of Section 3, supported by text and history, leads us to conclude that the presidency is an office under the United States, and number 2, the president is an officer of the United States, and 3, the presidential oath under Article 2 is an oath to support the Constitution. Trump asked us to hold that Section 3 disqualifies every oath-breaking insurrectionist. I love how they use all that. That's all language meant to convey a point, except the most powerful one, and then it bars oath breakers from virtually every office, both state and federal, except the highest one in the land. Both results are inconsistent with the plain language and history of Section 3. We therefore reverse the district court's finding that Section 3 does not apply to a president, include that Section 3 bars Trump from holding the office of president if its other provisions are met. Namely, if President Trump engaged in insurrection. Before addressing the findings, however, we consider President Congressional report, which premised some of the admissibility of its findings. Okay. So they did not err in admitting the January 6th report. Yes, that paragon of beautifulness there. Yes, and this is the issue here. Under the deferential standard review that governs, we perceive no error by the district court in admitting portions of the report in the evidence at trial. Remember, I said this when they were talking about this. They were going to leave this part alone for sure. The court made its findings, and they made its findings based on law. They were going to leave it alone, saying, at the very least, yes, they're going to claim he committed. This court made its determination. They were going to leave it alone. Now, I thought they would just say, whatever, we can't overturn them. But they're making the argument, well, this court said that, we're not going to overturn it, and because we can't overturn it, therefore, he's now disqualified. But, yeah. Analytical T says, is the oath lawyers take in America sworn to British law? No. Is the bar British law? No. Honest question, I've read that the bar is not what the general public is aware of. No. Literally, the concept of a bar is literally there's like a railing in court you're not allowed to cross into. As an attorney, I can pass through the bar. I'm allowed to be up there because that is, traditionally when the judge lived at the court, his chambers were where he lived. And you had the right to be in that area. As a commoner, you could not. So, no, that is not, that's kind of gets in the sovereign citizen nonsense there. So, Mr. Squiggles for $5. I didn't see this earlier. We need to read this here. Barnes said Biden was favored to win in Colorado with Trump on the ballot. Kennedy will likely win Colorado now. Wait, you mean Trump was likely favored to win, right? Wait. I thought Trump was favored to win in Colorado, but Kennedy will win now. Okay, well, this is going to make some interesting stuff happen, I guess. Yes, I'm piloting a maritime vessel. So, yes, I'm an Article 4 free inhabitant. They review a district court, and a district court is the trial court, evidentiary rulings for an abuse of discretion. And a court abuses its discretion when its decision is manifestly arbitrary, unreasonable, or unfair, which means basically they're always going to uphold it. And here, yes. They say we can only determine whether the trial court's decision fell within a reasonable range of options. Okay. And they talk about hearsay. Hearsay is an out-of-court statement offered in court to prove the truth of the matter asserted. They say it a little differently in Colorado, but it's an out-of-court statement offered in court for the truth of the matter asserted. Yes. Out-of-court statement offered to prove the truth of the matter asserted. Such statements are generally inadmissible except for reports of public officers or agencies setting forth factual findings resulting from an investigation made pursuant to authority granted by law. This exception, however, only applies if the report is trustworthy. Okay, well, they determine it's trustworthy, so spoiler alert, they determine the January 6th committee is without stain. I don't even need to read it to tell you that. It's amazing. So let's get on to this. The court, President Trump challenges the findings that he engaged in insurrection. The Constitution leaves those terms undefined. Therefore, we must make a legal determination regarding what the drafters and ratifiers meant when they chose to deploy those words in Section 3. Mindful of deferential standard review of the district court's findings, we conclude the district court did not clearly err and that the events considered an insurrection and that Trump engaged in that insurrection. Yes, that was such an insurrection. Yes, the most unarmed and yes. January 6th report was a flawless victory. Yes. Just Me says they never read the Amnesty Act of 1879. Well, it's all... Doesn't matter. They determine he's a bad man. So, I will point out, though, just me when you point that there, still the remaining Confederate leaders never got amnestied. A bunch of them did, but most didn't. So, why are we talking about an election that's not going to happen? Well, it'll happen. Winter Solstice, the Broncos won't be allowed to wear. Oh, hold on here. Oh, I got an email. What? Email, what? My email. It's a email for email. Okay, hold on here. I got to answer this. It's actually important. Sorry, guys. This is actually important. I need to... All right. Sorry. That came in. I had to actually answer that. It was important. It was important. As a general matter, we review findings of fact under a clear error or abuse of discretion standard, and we review legal conclusions de novo. When the issue is a mixed question of law and fact, Colorado courts have taken different approaches depending on the circumstances. For example, sometimes courts have done the clear error standard. Others have done a mandates de novo review. For our purposes here, when we're called on to review it, we will review the district court's factual findings for clear error and its legal conclusions de novo. So they're going to split the things here. Legal conclusions will be reviewed under de novo. The factual findings will be reviewed under clear error. Meaning, if it's not a clear error that's so manifestly unjustful, they're not going to overturn it. So, kind of gives you a hint of where they're going to go. Gives you a hint where they're going here. And spoiler alert, they're not going to... I have a feeling they're not going to say any of this was wrong. Just guessing. That these scary police, man, they said they was scared of the insurrection. So it's okay. This we are says Sean posting in Kiwi Farms is a high priority. It was not on the farms, I promise. Was it a shower email? Yes, that was a shower email. Is it a sub-email? Sub-email. What sub-email? Yes, no, they were not bulleted. Okay, dictionaries, both old and new. Dictionaries, the district court's order, and the briefing by the parties and the amici curiae suggested several definitions. Dictionaries, both old and new, suggest several different definitions of the word insurrection. For example, Noah's Webster's dictionary defined insurrection as a rising against civil or political authority, the open and active opposition of a number of persons with the execution of law in a city or state. So Chaz was an insurrection. Okay. Is equivalent to sedition, except that sedition expresses a less extensive rising of citizens. Okay. It differs from rebellion, for the latter expresses a revolt or an attempt to overthrow the government, to establish a different one, or place the country under another jurisdiction. Okay. So they go to 1856, defining insurrection as rebellion of citizens or subjects of a country against its government. Webster's Modern Dictionary defines insurrection as an act or instance revolving against civil or political authority or against an established government, or an act or instance of rising up physically. Does that mean 2020 was an insurrection? Huh. In light of these and other proffered definitions, the district court concluded that an insurrection used in Section 3 is a public use of force or threat of force by a group of people to hinder or prevent the execution of the Constitution of the United States. That is going to be interesting. That's the definition, because a lot of people have interrupted the Constitution, preventing it from being executed. Like, what is that exactly going to be? Finally, we note at the oral argument, President Trump's counsel, while not providing a specific definition, argued that an insurrection is more than a riot, but less than a rebellion. We agree that an insurrection falls along a spectrum of related conduct. So they're talking about spectrums, and yes, they know all about spectrums. They point out insurrection against the government may or may not culminate in an organized rebellion, but a civil war always begins by an insurrection against a lawful authority of the government. Yes, but if that's the case, then every civil war, an instance where it starts out as one guy beating the shit out of the police officer or the government enforcer, that's the insurrection right there. That's where they're starting it at. Yeah. Although treason by levying war in cases of civil war may involve insurrection or rebellion, they're usually the first stages. They do not necessarily reach the actual levying of war. Yes. Okay, an insurrection is distinguished from riot, and offenses that connected with mob violence by the fact that in insurrection there is an organized and armed uprising against authority or operations of government, while crimes growing out of mob violence, however serious they may be, and however numerous the participants, are simply unlawful acts and disturbance of the peace, which do not threaten the stability of the government or the existence of political society. Like, was that really going to stop the government from working? No, it didn't. So, but we part company with him when he goes one step further. No authority supports a position taken by President Trump's counsel at oral argument that insurrectionary conduct must involve particular length of time or geographic location. Although we acknowledge that these definitions vary and some are arguably broader than others for the purposes of deciding this case, we need not adopt a single all-encompassing definition of the word insurrection. You kind of have to, though, because it helps to have. So we're now in the business of overly broad definitions. Well, it can be really broad. Definitions should be vague, should be like narrow and defined, not vague and broad. That's not how this works. That's not how this should work. Rather, it suffices for us to conclude that any definition of insurrection for purposes of Section 3 would encompass a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish a peaceful transfer of power in this country. So that's really broad. And then with the broadness, they're willing to accept broad and vague definitions because they want to have a broad definition themselves. That's, yeah, words mean things. Yes, they got to mean things. So, yeah, that's where I have, like I said, this is where I have the issues with stuff. Okay, some of their arguments, fine. Like, it's going to be really hard for me to get around them, but I'm also not, Gorsuch. I'm not Thomas. I'm not Barrett. I'm not, Kavanaugh, whoever. But some of this here, well, so we're now in the broad and vague or definition game. Like, come on now. The required force or threat of force needed not involve bloodshed, nor must the dimensions of effort be substantial as to ensure probable success. Moreover, although those involved in an act must act in a concerted way, they need not be highly organized at the insurrection's inception. By that definition, then it does say, they're like, oh, it doesn't include a mob. It's distinguished from a riot, and offenses connected with mob violence. But now they're saying it could be mob violence because it doesn't need to be organized. An insurrection may be a loosely organized affair. It may start as a sudden surprise attack on the civil authorities in a community, like a riot, with incidental destruction of property by fire or pillage, even before the military forces of the constituted government have been alerted or mobilized into action to suppress the insurrection. So you're saying that mob, well, it's an insurrection, but you said it was a mob, so therefore it's not an insurrection. Like which one is it? Like, I'm kind of confused here. Like, what's our game plan here? Because this is kind of, Isn't that a quinky dink? Hi, Clyde. Yes, Rodney King was an insurrection. Lil Wars, yes. Ilwar says the 2020 riots are an insurrection. Yeah, I guess on this definition, they are an insurrection. You're seeking to stop the government. Shawfaw says SCOTUS has no teeth. Yeah, well, we'll get to that point. Yes. Porcelain Thunder. Yeah, I think they mean martial and military martial power, governmental's power period. So I'm not that's a distinction I'm not worried about. Yes, the doggo barking. Clyde caused an insurrection. And Claude, yes, Chaz and Chop in Seattle was an insurrection. Trump should have fucking carpet bombed that area then, apparently. So, but that was different. So, so the question thus becomes whether the evidence before the district court sufficiently established the events constituted a concerted and public use of force of threat by a group of people to hinder or prevent the government from taking the actions necessary to accomplish the peaceful transfer of power. We have little difficulty concluding that substantial evidence in the record supporting each of these elements, and as the district court found, the events of January 6th constituted an insurrection. Okay. It is undisputed a large group of people entered the Capitol, and their actions was so formidable that the law enforcement officers on site could not control it. Moreover, contrary to President Trump's assertion that no evidence in the record showed the mob was armed with deadly weapons or that it attacked law enforcement officers in a manner consistent with a violent insurrection, the district court found and millions of people saw on live TV, okay, once again, we're in recordings of which were introduced in the evidence of the case, that the mob was armed with a wide array of weapons. Okay. Yes, they use metal bars from police barricades and the officers' batons and riot shields. They use the shields. They violently assaulted the officers who were defending the Capitol. The fact the actual and threatened force used that day cannot reasonably be denied. Well, it kind of is important, though. You're arguing that, well, a mob can't be part of it, but a mob, could be part of it. Well, when does the mob become insurrectionist? That's not clearly defined here, and I think that's a problem from this court. Now, is the Supreme Court of the United States going to hang its hat on it? I mean, let's be real. I'm not counting on the Supreme Court making the right decisions here. They're going to say, oh, sorry, we're out. It's a political question. We can't decide it. And it's going to stand. I mean, that's the thing right now. That's the thing right now. We're gonna bring this in. We're gonna bring this in. We're gonna bring this in right now, real quick. The Supreme Court is not going to get in the way of this. They're gonna punt. I'm just telling you, it is what it is. Not trying to blackpill you, just giving you the reality. If I'm wrong, I'm happy to be wrong, and I'll eat my hat. But I'm probably not going to be wrong. And I think you guys know that too, sadly. I'm not saying sadly you guys know that, but I think we all acknowledge the sad reality of what's going on. So, Augustine says, what hat? I'll make a hat out of cookie dough and eat it or something. I don't know. I got a pretty, freaking big head, though. My head's 63 centimeters in circumference. So it'll have to be a big hat. So. Track Golfer says, can I see the hat you're going to eat? And are you going to eat all of it? Well, if I don't have to eat it, I won't make it. But if I need to eat a hat, I'll make a hat and eat it. So that hat's to be determined. Philip Coggins for $5. Thanks, Philip. Is saying, Clown World prediction. SCOTUS denies cert for standing. It'd be fucking hilarious if they did. But I think they're going to be like, oh, it's a political question. We can't do it. Just telling you. Just telling you. Like I said, not trying to doom, but 'tis the reality of it all. My next angle, the Great American Baking Show. If I could have Paul and is Mary Berry still alive? Mary Berry. Oh my God, she's still alive. Oh my gosh, hell yes. If I had Paul Hollywood and Mary Berry, she can talk about how things are just scrummy. Fuck yeah, I'd have her on. I'm not going to have those two morons that are on the Great British Baking Show now. Those two people that are now suck as the hosts. You know what I'm talking about. They're just bumbling idiots. If we could have the original people, that'd be perfect. Yes, no soggy bottom. Yes, reality is fake and gay. Yeah, that's yeah. So, oh, and Ilworth saying it'd be funnier if they say it's a political question after the election and then say it's moot. Yeah, they're gonna come up with all. They're gonna say latches and unclean hands. So, yeah. So let's keep going here. Substantial evidence in the record further established the use of force was concerted and public. Was it really concerted? As a district court found ample support, the mob was coordinated and demonstrated a unity of purpose. Most mobs demonstrate a unity of purpose. There isn't just a mob of random people just attacking each other. It's generally the people against the government. So, yes, all mobs are generally done that way. And there's some level of coordination. They marched to the Capitol building chanting in a manner that made clear they were seeking to inflict violence against members of Congress. Did they? And upon breaching the Capitol, the mob immediately pursued its intended target, the certification of the presidential election, and reached the House and Senate chambers within minutes of entering the building. All of them did, or some of them did, because a lot of them didn't. A lot of them just fucking wandered around. Some of them took tours. Some of them took a dump on Nancy's desk. One guy stole the lectern. They all didn't do it. So was it really a coordinated and demonstrated unity of purpose? Was it really? Well, it was a demonstrated unity of purpose until they all did whatever they wanted. I don't know. Yeah, Baked Alaska was streaming. So, yeah. Yep. Oh, and I'm sure people on Twitter are beating their dicks raw over this now. So, what better at this point? Oh, Sniper said I was muted. Okay, thank you. So, oh. Yes, some started smoking weed in the rotunda. Yes, that organized purpose all of a sudden fell apart. No, I don't think so, said Fed Alaska was recording evidence. Yes, because he was a Fed. Can a ballot have a name written in by a citizen? Even those trying to get on a write-in ballot have to fill out their intent of running with the Secretary of State for Colorado. And even then, if you don't qualify, the Supreme Court of Colorado said he does not qualify. So by that logic, you can't be a write-in candidate. It's no different than if you tried to write in a 15-year-old to be president. He's not old enough. So, yeah. Kia Patrick says the Krasstein brothers are growing nuts. Yeah, well, they should just be thankful they never got prosecuted for the crypto scamming they were doing. So, yeah. So good for them. Saniko says, would a class action lawsuit be a plausible way to overrule this thing? No. Nope. So, Richard Gruber says, what if Trump gets a significant number of write-ins in the general? Doesn't matter. He's not eligible. He would not be eligible under Colorado's ballots, so those ballots would be invalid. That's like if you wrote down Mickey Mouse. Mickey Mouse doesn't win. Like all your other voting would count. They would just not count that one. If you're running for office, you have to be eligible for office, and Colorado has determined he's not eligible for office, so it doesn't matter. Now, if the Supreme Court comes in and says, no, Colorado doesn't work, which, like I said, I don't think is going to happen. I think they're going to say, lol, we don't care. Then he can't be on there. Track Golfer says, so nothing has changed. The elites still rule. Yes, they have always ruled, and they will continue to rule. So, yes, Kia Patrick saying, so you're saying when I wrote in Latheris the Blind in 2008, it didn't count? Yes, sorry, it didn't count. So, yeah, we're going to keep going here. Finally, the substantive evidence in the record shows the mob's unified purpose. Well, unified purpose. Well, they weren't smoking weed and go wandering off in every direction. Yeah. Was a hinder to prevent Congress from counting electoral votes as required by the 12th Amendment and from certifying the 2020 presidential election. That is to preclude Congress from taking the actions necessary to accomplish a peaceful transfer of power. As noted above, soon after breaching, the mob reached the House and Senate chambers where the certification process was ongoing. This breach caused both the House and Senate to adjourn, halting the certification process. So if I pulled a fire alarm, would that count as stopping the Congress from taking actions necessary? I mean, if someone pulls the fire alarm, will that count? Asking for a friend. In addition, much of the mob's ire, which included threats of physical violence, was directed at Mike Pence. Well, Pence is a scumbag, who in his role as president of the Senate was constitutionally tasked with carrying out the count. As discussed more fully below, these actions were the product of Trump's conduct in singling out Pence for refusing Trump's demand. Pence declined to carry out his duties. In short, the record amply established the events of January 6th constituted a concerted public use of force, threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish a peaceful transfer of power in this country. Under any viable definition, this constituted an insurrection, and thus we will proceed to consider whether presidential Trump engaged in this insurrection. Okay, when we get to engaged as to embark in an affair, that's not very helpful. Engage means to begin or carry on an enterprise or to take part or participate. Okay. But that's the 2002 version. Attorney Stanberry's opinions on the meaning of engage, which he issued at the time the 14th Amendment was being debated. And this is the Attorney General back in the 1870s. Said, which he issued at the time the 14th Amendment was being debated, are in accord with these historical terms and modern definitions. Attorney General Stanberry opined that a person may engage in insurrection or rebellion without having actually levied war or taken arms. Thus, in Attorney General Stanberry's view, when individuals acting in their official capacities act in furtherance of the common unlawful purpose or do any overt act for the purpose of promoting the rebellion, they have engaged in insurrection or rebellion. So does that, like, if I haven't done any of those things, so somebody who said on Twitter, rock on, dudes, hang 10, get that bag. Does that mean they've engaged in insurrection? That's, we'll see. So accordingly, disloyal sentiments, opinions, or sympathies will not disqualify. But when a person says by speech or writing, incite others to engage in rebellion, he or she come under the disqualification. So, turning to the meaning of engagement for purposes of Section 3, although we found little precedent directly on point, cases concerning treason that have been decided by the time the 14th Amendment was ratified provide some insight into how the drafters of the 14th Amendment would have understood the term engaged in. So they say, if a body of men assembled for the purpose of effecting by force a treasonable purpose, all who perform any part, however minute, however remote, from the scene of the action, who are actually in league with the general conspiracy, are to be considered as traitors. In other words, an individual need not directly participate in the overt act of levying war or insurrection for the law to hold him accountable as if he had. Jeez. Try to not do that, and it still doesn't highlight it right. If he was present, directing, aiding, abetting, counseling, or countenancing it, he is in law guilty of the forcible act, nor is even his personal presence indispensable. Though he be absent at the time of its actual perpetuation, if he directed the act, devised, or knowingly furnished the means for carrying it into effect, instigating others to perform it, he shares their guilt. In treason, there are no accessories. Well, ladies aren't going to like that. They like to accessorize. In the foregoing definitions, authorities to be generally consistent, and we believe the definition adopted and applied in the district court is supported by a plain meaning of the term engaged in as well by the historical authorities discussed above. Accordingly, like the district court, we conclude that engaged in requires an overt and voluntary act done with the intent of aiding or furthering the common unlawful purpose. So, there we go. That is what they're going to do there. So, they are determining that he engaged in it. In concluding, so we hasten to add that we do not read engage in so broadly as to subsume mere silence in the face of insurrection or mere acquiescence therein, at least an affirmative duty to act. Rather, as Attorney General observed, the force of the term to engage in carries the idea of active rather than passive conduct and of voluntary rather than compulsory action. So the question remains whether the record supported that finding that Trump engaged in insurrection by acting overtly and voluntarily. Again, mindful of our applicable standard review, we conclude that it did. Well, yeah, no shit at this point. And the evidence shows us why this is so. Substantial evidence showed that even before the November 2020 election, President Trump was laying the groundwork for a claim the election was rigged. Okay. The only way we're going to lose this election is if it was rigged. Okay, he's allowed to say that. President Trump then lost the election despite the fact that his advisors repeatedly advised him there was no evidence of widespread voter fraud, no evidence to show that Trump himself believed the election was wrought with fraud. Trump ramped up his claims the election was stolen from. That no evidence. I don't remember that being proven in court, but okay. It's 5 days. Wasn't there for all of it, but okay. Okay. I mean, if you're reading the January 6th indictment Jack Smith put together, that's there, but that's not. I don't think that was proven in. Whatever. I'm just saying. Rabbit Stick has been a member for 1 month. Thank you for the support. Is saying anyone started crowdfunding for Komatsu 355Ds in Denver yet? Not yet. Well, you're going to start crowdfunding for all the concrete and steel as well. And undertook efforts to prevent certification results. Okay. And he undertook efforts to prevent the certification results. For example, December 13th, he tweeted, swing states that have found massive voter fraud, all of which them cannot legally certify these states without committing a severely punishable crime. Okay. Trump sought to overturn the elections by exerting pressure on Republican officeholders in states. On this point, relevant to Trump's intent in this case, many of the state's officials targeted by Trump's were targeted and subjected to a barrage of harassment and violent threats by his supporters. Trump is well aware of these threats, particularly after Georgia election official Gabriel Sterling issued a public warning to Trump to stop inspiring people to commit acts of violence, or someone's going to get killed. Well, Trump responded by retweeting a video of Sterling's press conference with a message repeating the very rhetoric that Sterling warned would result in violence. Trump continued to fan the flames, propelling the Stop the Steal movement. Specifically, on January 6th, the Stop the Steal organizer has held dozens of rallies around the country, proliferating President Trump's election disinformation and recruiting attendees, including members of violent extremist groups like the Proud Boys, who are nothing but proud Western chauvinists who refuse to apologize for creating the modern world. The Oath Queefers, bunch of boomers, and the Tree Percenters, a bunch of more boomers. QAnon conspiracy theorists, just douchebags and weirdos. And white nationalists. White nationalists, oh no. Stop the Steal leaders also joined 2 million MAGA marches at Washington, D.C. on November 2020 and December 2020. Again, as relevant to President Trump's intent after the November rally turned violent, Trump acknowledged the violence, but justified it as self-defense against the Antifa scum. There's always justified against Antifa scum. With full knowledge of these sometimes violent events, President Trump sent sometimes violent. So, well, sometimes they're violent, but other times they weren't. So, what's he supposed to do? Well, sometimes, like, they're not even saying predominantly violent or mostly violent or nearly entirely violent. They're saying, yeah, sometimes violent. Trump sent the following tweet urging his supporters to travel to Washington, D.C. on January 6th. Say, big protest on D.C. Be there, will be wild. Okay. At this point, the record established that President Trump's plan was that when Congress met the certified election results, Pence could reject the true electors who voted for Biden, certify a slate of fake electors supporting Trump, or he could return the slates to the states for further proceedings. Far-right extremists and militias such as the Proud Boys, they're militia? There's the Oath Queefers and the Tree Percenters, viewed Trump's tweet as a call to arms and began to plot activities to disrupt the joint session of Congress. Well, some allegedly did, but a bunch of those guys got acquitted of sedition. So did they really commit sedition? I guess not. In the meantime, Trump repeated his invitation to come to January 6th at least 12 times. 12 times? If he had only done it 11, would that have been better? Or is 13 better? Is there a sweet spot there? I don't know. Rocco Rockwell, thank you for becoming a member. I appreciate it. Patty Leather says a militia founded by a Canadian comedian who stuffed a dildo up his ass. Yes. Yes. Yes, Rockwell, yes. We can have fire mostly peaceful, but not apparently now. Oh. Let's keep going, guys. We're going to finish this up quick because I think we're getting to the point of the stuff we need to talk about. On December 26th, Trump tweeted, if a Democrat, the Democrat senators would consider an act of war and fight to the death. Mitch McConnell and the Republicans do nothing. Well, that's true. Who do not want to let it pass, no fight. Yeah, well, McConnell doesn't do anything. Although McConnell's like, just like Nancy Pelosi. And then like Dianne Feinstein. So Trump retweeted a post from Kylie Jane Kramer, an organizer of the January 6th March for Trump, that stated, the cavalry is coming. Ugh, Mr. President. January 6th, Washington, D.C. Yes, the cavalry. The cavalry. The cavalry. The mountain where Jesus was crucified is coming to help you. Yes. Yes. Does that mean a reasonable person can assume a real cavalry charge is coming through? The charge of the light MAGA brigade. Pepe's to the right of them. Pepe's to the front of them. Pepe's behind them. Stormed and thundered with memes. With memes and rees. Boldly they shitposted. Into the jaws of death. Into the mouth of bands. All in the valley of cringe rode the 600. I hope that gets clipped. God, I tried. If you guys don't know, that's Tennyson. If you guys don't know Tennyson, good Lord, read a book, please. Jessamy says, oh, I did not see one damn horse, so the cavalry never made it. Will Warren says, I'm curious to get into Brandenburg v. Ohio. We're gonna speed read through some of this to check it. So we'll see. We'll see. Iconoclast's books are banned where I live. I are not allowed to read. That's a shame, says, sorry, only Harry Potter is read in this house. Thanks. Oh my gosh. Yeah. Patty says the last charge. Well, it's just the charge of the Light Brigade. Because it was their last charge. They weren't too many of them afterwards. So yeah, that was it for them. Oh. If you're going to read a book, read The History of Central Banking and the Enslavement of Mankind. Yeah, well, we're going to keep going. We're going to keep going here. Okay. The foregoing evidence established that Trump's messages were a call to his supporters to fight and that his supporters responded to that call. Further supporting such a conclusion was the fact that multiple federal agencies, including the Secret Service, identified significant threats of violence in the days leading up to January 6th. Did they? These threats were made openly online and they were widely reported in the press. Agency threat assessments thus stated that domestic violent extremists planned for violence on January 6th with weapons including firearms and enough ammunition to win a small war. Then where was the National Guard? Looking at you, Mayor Bowser. Where were they? Well, I don't know. Along the same lines, the Federal Bureau of Investigation, yes, the paragon of Truth and Justice in the American Way, when they're not shooting Vicky Weaver in the face, received many tips regarding the potential of violence. Yeah, I'm sure these tips are legit. Yeah, from one of their snitches. The record reflects Trump had reason to know of the potential for violence. Okay. So what it could have been violent, he should have been like, sorry, we're not doing it. As president, he oversaw the agencies reporting the foregoing threats. Yes, which were not copacetic with him and were hiding things from him. Remember, the military hid the fact they were still running ops in Syria. When they told him, nope, we're withdrawing, like you ordered. In the meantime, they were increasing troop presence and doing all kinds of crap. Katrina Pearson, a senior advisor of both of Trump's campaigns, testified at a January 5th meeting that Trump chose the speakers for the January 6th event, which he too would speak, avoiding at least some extremist speakers. So yeah, well, oh, it's going to be bad, but they kicked people out. So, and then he knew radical political extremists were going to be in Washington, D.C. on January 6th and would likely attend a speech. Oh, sorry, there's going to be bad people who are going to show up at my speech. Sorry. You know, the heckler's veto, we can't allow it, guys. Yeah. Chance says just enough ammunition to win a small war. President Zelensky would like to know your location. Will you trade ammunition for cocaine? So. Kip Ethics says online threats. Yeah. Some of you guys are cool. Don't go to DC tomorrow. Yeah. Don't go to homeroom tomorrow. Stay home. Oh. Yes, Porcelain Thunder saying speakers were they JBL's Electro voice? I don't think that's the speakers they're talking about. I don't think so there, honey. January 6th arrived. It arrived. And in the early morning, Trump retweeted, if Mike Pence comes through for us, we will win the presidency. Many states want to certify the mistake they made, certifying incorrect and even fraudulent numbers in a process not approved by their state legislators, which it must be. Mike can send it back. He followed the tweet later with another that said, Mike Pence has the courage to send it back. Do it, Mike. This is a time for extreme courage. Well, even if it was right, Mike Pence is not a man of courage. Regardless of whether it's right or wrong, Mike Pence is not a man of courage. I can say that much. He is a tool. Born of a Black & Decker drill and a Makita Sawzall. Okay, so those tweets put a significant target on his back. A significant target. About the same time, tens of thousands began gathering around the Ellipse for his speech. To enter the Ellipse itself, attendees were required to pass through magnometers, meaning metal detectors. Notably, from the approximately 28,000 attendees who passed through these security checkpoints, the Secret Service confiscated hundreds of weapons and other items, including knives or blades, pepper spray, brass knuckles, tasers, body armor, gas masks, batons, or blunt instruments. Like how many? How many out of 28,000? How many? How many knives? Are we talking about pocket knives? Are we talking about like Crocodile Dundee? Like, oi, this is a knife. Talking about dudes with like scimitars and like rapiers, like Elizabethan rapiers. Like what did they have? They confiscated some. I don't know how many, but oh my gosh, it was scary. Approximately 25,000 additional attendees remain outside the Secret Service perimeter, thus avoiding the magnometers. I don't think there was that much room for everybody. I think that was like 30K was the max for the actual ellipses area. Trump then gave a speech in which he literally exhorted his supporters to fight at the Capitol. Among, this is a big word, meaning including some of the things he said, but not limited to these, meaning we're not going to use all the words he said. He told the crowd, we're gathered here to save our democracy. Okay. Republicans are constantly fighting like a boxer with his hands tied behind his back. It's like a boxer. And we're going to have to fight much harder. Okay. To confront, and after this, we're going to walk down there and I'll be with you. Okay. We're going to walk down to the Capitol and we're going to cheer on our brave senators and congressmen and women. Okay. He's going to cheer for them. Oh, no. You have to show strength. You have to be strong. Yes. Well, what does that mean? You're going to have to not act like a savage. And a lot of people went into the Capitol building and acted like fucking retards. So, yes. At least they weren't shitting in Pringles cans. When you catch somebody in a fraud, you're allowed to go by very different rules. Okay, well, what does that mean? The most corrupt election in history, maybe of the world. It's not just a matter of domestic politics, it's a matter of national security. And we fight. We fight like hell. And if you don't fight like hell, you're not going to have a country anymore. What about the peaceful part? Go peacefully. Indeed, after Trump instructed his supporters to march to the Capitol, members of the crowd shouted, storm the Capitol, invade the Capitol, and take the Capitol. And before he even concluded his speech, Trump supporters followed his instructions. The crowd marched on the Capitol, many carrying Revolutionary War flags. Oh no. And Confederate battle flags. Oh no. Quickly breached the building and immediately advanced to the House and Senate chambers to carry out their mission of blocking the certification of the 2020 election. By 1:21, Trump was informed the Capitol was under attack. Rather than taking action and end the siege, I guess they wanted him to just start fucking killing people. Approximately 1 hour later, he tweeted, Mike Pence didn't have the courage that what should have been done to protect our country and our Constitution, giving states a chance to certify a correct set of facts. Although, just going back to this, even if he had said, what are you doing, you idiots? Stop. Would they say, oh, you haven't committed an insurrection? Oh, no, they were going to say you did it anyway. So let's not lie and act like there were ways to turn back. They're already focusing on what he did beforehand. So, no, this isn't like he could have fixed this, according to the Colorado Supreme Court. This tweet was read over a bullhorn to the crowd at the Capitol and produced further violence, necessitating the evacuation of Mike Pence from his Senate office to a more secure location to ensure his physical safety. Next public comments were two tweets at 2:38 and 3:13, encouraging the mob to remain peaceful and stay peaceful. Obviously, the mob was not all peaceful, but neither tweet condemned the violence nor asked the mob to disperse. Well, asking them to stop and be peaceful, what do you want? Okay. Throughout these several hours, Trump ignored pleas to intervene and instead called on senators, urging them to help to play the electoral count, which is what the mob, upon Trump's exhortations, was trying to achieve, and Trump took no action to put an end to the violence. To the contrary, as mentioned above, when told the mob was chanting, hang Mike Pence. Well, actually, I'm just going to leave that there. They said, hey, it says hang Mike Pence in the thing. I'm just reading it. Trump responded that perhaps the vice president deserved to be hanged. Oh. President Trump also rejected pleas from House Republican leader Kevin McCarthy, who, great guy, him, imploring him to tell his supporters to leave the Capitol, stating, well, Kevin, I guess these people are more upset about the election than you are. Finally, at 4:17, Trump released a video urging the mob to go home now. Even then, he did not condemn the mob's actions. Well, you bitched at him up here saying, it didn't condemn the violence nor ask him to disperse. You wanted him to do he did one of them. Now you want both? Okay. Instead, he sympathized with those who have violently overtaken the Capitol, telling them he knew their pain. He told them that he loved them. They were very special. And he repeated his false claim that the election had been stolen, notwithstanding his landslide victory, thereby further endorsing the mob's efforts to try to stop the peaceful transfer of power. A short while later, Trump reiterated the supportive message to the mob by justifying its actions, tweeting at 6:01. These are the events would happen when a sacred landslide is unceremoniously stripped away. Go home and love and peace. Trump concluded by encouraging the country to remember this day forever. You know, you'd argue somebody really engaged in insurrection when they do this and then he pardons them all, but he didn't do that. So, I don't know. Hey, whatever. We conclude that the Trump engaged in insurrection, direct and express efforts over several months, exhorting. Is that really, should it be exhorting or extolling? Extolling or exhorting is support. Is that proper versus extolling? You know, I mean, like it's. I mean, are we gonna extorting versus extolling versus exhorting? I mean, yes, exhorting is to use speech to cause action, yes, but extolling is to praise someone or something very much. I mean, he was extolling them as well. But yeah, encouraging them to support. Yeah, I mean, afterwards he's extolling them, but beforehand he's exhorting. Yeah, he's exhorting them before and afterwards. Yes, yeah, there we go. Winter Soldier says Kino Casino's going over Ricada screaming at me. It took him fucking long enough. I'll have to watch that. Maybe I'll watch that and build a model tonight. We might do that. So, yeah, this is actually the exhorting's right because extolling would be after the fact. The extolling is, and I misread this part. Extolling is the previous lead up. So, moreover, the evidence show that Trump undertook all these actions to, like they didn't tie Russia into this, aid and further an uncommon purpose that he himself conceived and set in motion to prevent Congress certifying the 2020 election, stop the peaceful transfer of power. I know he was just like Hitler. Colorado Supreme Court sees that. Interdimensional orange Hitler. You know, as our detailed recitation shows, he merely did not incite the resurrection. Okay. Even when the siege was going, he continued to support it by repeatedly demanding that Vice President Pence refuse to perform his duties and by calling senators to persuade them and stop the counting of electoral votes. Yada, 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 yada. The common unlawful purpose of preventing the peaceful transfer of power. He started a fight. He personally took action to try to stop the certification. Okay, well, for these reasons, we conclude the record fully supports Trump engaged. Okay. Now we're going to get to Brandenburg here, and this is the one I wanted to see. The January 6th was not protected by the First Amendment. Okay. Consider Trump's First Amendment challenge. We take an independent view of the record to be sure the speech in question actually falls within the unprotected category of information, communication. We have interpreted this independent review as being akin to de novo review. So they're literally looking at this brand new. Though we may give presumption of correctness to factual findings, especially those that do not involve the application of standards of law, or those that arise from complex cases such as this one, where the district court judge has lived with the controversy. Focusing on the findings by the district court, we therefore examine for ourselves the statements under which they were made. Okay. First Amendment protections and incitement. Congress shall make no law abridging speech. Yep. Okay. And speech, this robust protection for speech functions to invite dispute. Yes. Even so, the right of free speech is not absolute in all times and under circumstances. Chaplinsky v. New Hampshire, the fighting words case. First Amendment does not protect true threats. Watts v. United States. True. Speech is essential to criminal conduct. Packingham versus North Carolina. Or speech that incites imminent lawless action. Brandenburg v. Ohio. So again, the gold standard. Ohio men setting case law in the Supreme Court once again. this time Klansmen in Ohio. This is the last strand of First Amendment jurisprudence that the parties debate here. The First Amendment's guarantees do not permit a state to forbid or prescribe advocacy use of force of law, except where it's producing imminent lawless action and is likely to incite or produce such action. Okay. Under Brandenburg, it's whether the speech was explicitly or implicitly encouraged the use of violence. And 2, the speaker intended the speech would result in the use of violence or lawless action. And 3, the imminent use of violence was the likely result of the speech. Okay. And that's from the Sixth Circuit, applying it to the Brandenburg test, the context. Trump contends the district court erred by examining the broader context in which Trump's speech was made, thereby expanding the context to a relevant Brandenburg analysis beyond anything recognized in precedents. Okay, yeah, we disagree. Of course you are. In Shank v. United States, which has been overturned, Oh. Supreme Court addressed the first time the advocacy of legal conduct. Yes. Importance of the character of every act depends upon the circumstances in which it is done. Yes, this is no longer, Shank is no longer case law. Although the Supreme Court has said a little about analyzing incitement since Brandenburg, it offered some guidance regarding courts' use of other statements for context in NAACP versus Clairborne Hardware. In Clairborne Hardware, the Supreme Court considered speeches given by Charles Evers, the field secretary of the Mississippi NAACP, in connection with their boycott of white merchants from 1966 to 1969. Evers declared to black residents of Clairborne County that blacks who traded with white merchants would be answerable to him. And that any Uncle Toms who broke the boycott of their necks broken by their own people. Evers' statements also included that boycott violators would be disciplined by their own people, and he warned the sheriff could not sleep with boycott violators at night. I don't know. Today you could say, does that mean he can't be gay with them? I don't know. So let's see here. That's a shame for $4.99 says, thank you, by the way, for your support, saying, my ex told me I reminded him of a goddess from a Tennyson poem. I was so flattered, but then I read some of his poems. Yeah. Tennyson is not exactly a fan. Well, he's a fan of ladies in his own way. But yeah, some of those are... Yeah, it's not like it's an Aeschylus or Sophocles. Certainly not Agamemnon or Alcestis or anything like that quality-wise. So yes, I understand your chagrin there, much to your chagrin. Oh. There was by considering and placing value in the absence of corroborating evidence of his violent intentions, the court implied the courts may look to circumstances beyond the speech itself to determine intent. Yes. To an extent. I mean, how does that work with Counterman v. Colorado? Well, it's incitement is sparse. You have to know you're intending threats, though, because that's what is the subjective of the utterer. How does that work? Because counterman's kind of important now. While incitement precedent is sparse, the case law on true threats is instructive regarding the importance of context. So once again, they have to admit we got nothing to go on here. True threats and incitement are doctrinally distinct, but true threats are the closest cousin to incitement under the First Amendment. Yes. Oh, they do bring up counterman. Okay, good. I'm sure they're going to say how this is different, though. Yes, from Sotomayor, the dissenter. Actually, she concurred. So, the wisest of the Latinas. But except then they point out that it's maybe difficult to draw the line in some senses. Oh. Both exceptions involve exhortations regarding violence that derive from Schenck's clear and present danger test, which is unconstitutional. But okay. Multiple federal courts conducting a true threat analysis confirm what common sense says. When assessing what someone means to threaten another with unlawful force, we sometimes need to consider more than the behavior exhibited on occasion. Rejecting the argument of context means the direct circumstances surrounding the delivery of the threat, and instead of concluding that we, so far as we can tell others, conclude all of the circumstances in order to determine whether a statement is a true threat. Okay. But you can't, though. I mean, literally, Counterman v. Colorado says you can't, though. You've got to focus on the subjective of the person uttering it at this point. So maybe I'm an idiot, but I don't know how you square that circle. So that's okay if I'm an idiot. That's fine. Won't be the first time, won't be the last time. Nico saying, will the U.S. Supreme Court be more likely to pick up this up since they appear to miscite case law? Well, I mean, here's the thing. I'm thinking, to me they are, but I think there's probably a well-reasoned argument they're not. Certainly, I'm willing to be wrong. And I mean, that's how that goes when interpreting things and making legal arguments. I think it means this, and I think somebody else thinks it's something else. Well, generally speaking, one of us is going to be more correct than the other. Usually, it's not like we're both right. You know, somebody's going to be more correct than the other, or we're both wrong. But like I said, guys, I don't think SCOTUS is going to fucking help. You know, it's kind of like the, little flip song, game over. I think that's pretty much it for Colorado. So they argue so too with incitement. Context matters. That is not to say, as Trump contends, the district court found that may consider any speech ever uttered by him in evaluating the incitement. Of course, there are limits, but we need not define those outer limits now. Then what are the limits? Like, if you're not going to, how do we know? You're saying, well, these are, okay, well. Instead, we simply conclude it's appropriate for the district court to consider Trump's history according to extremists and endorsing political violence as legitimate and proper, as well as his efforts to undermine the legitimacy of the 2020 election results and hinder certification of the Electoral College results in Congress. I mean, it's not like he, was hanging out with the president, the leader of the Weather Underground or anything like that. Courting extremists and endorsing political violence. I guess I'm whatever. With this in mind, okay, so yeah. The three-prong test. Encouraging use of lawless action. District Court made dozens of findings we've already outlined, discussing why the court concluded Trump engaged in insurrection. We incorporate those observations here by reference and supplement with other illuminating record below. For example, District Court found that at a February 2016 rally, Trump told his supporters in the old days, and this is what they got to go back. So they're not gonna define the limits, but hey, we're allowing her to go back that far. March 2016. Are you serious? And during 2020 election cycle, Trump threatened to deploy the military. Wait, hold on. To deploy the military to shoot looters amid the protests of police killing of George Floyd. Wait, so you don't want him to suppress an insurrection? I mean, that was a... Wait, hold on. Time out. Okay. We talked about this. A mob working towards affecting governmental change. The court just said that could be an insurrection. So a riotous, violent mob going after the government for its actions and wanting it to stop, which then had looting and wanton violence attached to it, which, remember, we said not everybody has to enact, a general unified goal, but we acknowledged to January 6th, not everybody did the same thing. Everybody kind of did their own stuff. To go suppress that, that's violence, though. But he is saying, I'll suppress these sons of bitches. But that's violence. I don't know. Is it just me? Is it just me, or you guys getting what I'm getting here? Getting at what I'm getting at? So that's a shame. Says so much for imminence. Yeah. Yep. He's been a bad man forever, and he's the second coming of Hitler. We know what Hitler did before. So if I'm suppressing a insurrection, I'm inciting violence. Are you trying to say all violence is not warranted then? Because that's a weird stand, but it's again, I'm not the Colorado Supreme Court, so whatever. And he told the Proud Boys to stand back and stand by during a debate. Yeah, he told them to stand down. Isn't that what you want? And he told people, hey, don't be violent. Stand back and stand by. Stay out of the way. I'll tell you what you're doing. Don't do anything else. Well, that's inciting violence. I said, don't do it. Well, you're talking to him. Yes, and the professor who is qualified as a political extremism expert, including how extremists communicate and how the events leading up to January 6th attack relate to long-standing patterns of behavior and communication by extremists. I know all about Nazis. I'm a doctor of Nazi studies. Just bad guys. Violent far-right extremists understood that Trump's calls to fight, which most politicians would mean were only symbolic, were when spoken by Trump, literal calls, only him. You know, fight, 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 fight. No, they just don't mean it. Fight. Oh, God, that's the call to violence. Okay. So his statements negating that sentiment were insincere and existed to obfuscate and create plausible deniability. So he didn't say anything to stop the violence. Well, if he did, we wouldn't have believed him anyway. Brilliant logic. Brilliant logic there, guys. Brilliant logic. You know, not to offend Joe, but you could almost say this is good logic. Just absolute garbage. Absolute garbage. Absolute garbage. Like, how do you win? How do you win with this? Well, you didn't say stuff. Okay, well, I did the other times. I don't believe that was legitimate, though. So is there any way I could have pleased you? No. You know, that's Trump's knowing encouragement and promotion of violence to develop and deploy a shared coded language with his violent supporters. Yes, when I say don't do something, that means do it. When he says don't be violent, that means be violent. When he says be violent, that means be violent. When he says anything, it means be violent. I've cracked the code. Oh, okay, God. Just, I don't know what more to say here, guys. You know, they point out in short, the district court found that this speech was understood as a portion of the crowds that called arms. And the district court is not the first to reach this conclusion. In Thompson v. Trump, the U.S. District Court for the District Court of Columbia found that President Trump invited supporters of D.C. Yeah, but this got all shot down. This case got tossed. So, plausibly, which means not saying a positive instigation of a mischievous act. Okay. So, just, yeah, guys, this is just, I'm assuming it's, Yeah, and then the rest of this is the Colorado state law stuff here. Yeah, that's I I'm I'm done. I'm done. I mean, seriously. Seriously. A portion of the crowd, fucking objective standard. Exactly. Exactly. Yes. No, no. Yes. We're not going to give you the limits, so we're just going to be extremely overbroad and completely arbitrary in what we decide. So one judge dissented, which, it's a per curiam decision, but some judges dissented. So it's like, well, how do you know who did what? I'm just saying, like, that's kind of funny. They listed as per curiam, but these judges are dissenting. A couple other judges, the Chief Justice dissented. So, but yeah, we're gonna just. So yeah, the district court erred when it determines Section 3 doesn't apply to the president. We therefore reverse the district court's judgment. I'm surprised they don't just say bye bye, Orange Man. Accordingly, we conclude that President Trump's qualified for holding the office of president under Section 3. It would be a wrongful act in the election code to list him as a candidate on the ballot. Therefore, the secretary may not list him. But we stay our ruling until January 4th, the day before the date to certify it. If review is sought in the Supreme Court before the stay expires, it shall remain in place. And the secretary will have to include his name on the ballot until that's resolved. So 3 judges, that's 7 judges total. It was a 4-3 decision. So there we go. Guys, we plowed through it. 134 pages. We did it, chat. We did it. Oregon's saying potentially fuck this. Yes. Strange how the left can only hear the dog whistles. Yes. I can't hear them. Oh. Darby O'Hara says, coded language, well, where's the decoder? I agree. Where is the decoder? What is this? So, Kino Sino's covering Nick tonight. Well, maybe we'll work on a model. We'll work on the model iconoclast you got for me. I'll probably play with that a little bit and start working on it. Taking a look at it, getting it ready, because the tank, El Tanko, is done. I just need to glue the machine gun on top. So we'll work on other stuff. The best part is using Shank. Yeah, well, whatever. It says, someone get to find the decoder. Get a Navajo. Yes, get a code talker. Dig one up. I think there might be 1 or 2 still alive. Yes. I missed some. Could you repeat it? No. But yes, that's a shame. Yeah, like I said, I'm willing to be wrong. I'm far from being the best legal mind out there. I don't deny it. I admit it fully. But fuck, even I'm having trouble with this. But hey, they're super smart judges on the Colorado Supreme Court. See if we can see what the Colorado Supreme Court's political divide is. This is interesting. So the Colorado Supreme Court's 7-member bench was entirely appointed by Democratic governors, 6 of whom won the retentions elections, and the 7th will run to do so next year. Well, let's just see all the hooting and hollering that exists on Twitter. So, Barnes says, with Trump off the Colorado ballot, Biden is a strong favorite to win the state. Trump off the ballot, there's a good chance Biden loses the state to Robert Kennedy. Democrats might want to rethink their strategy. Well, that'd be fucking hilarious. This is I'm hope that would fucking make my day. Now I'm hoping, and the thing is, other states though are going to use this and say, well, Colorado said we could do it, and we're gonna they're gonna basically copy and paste. So Cringe Paler said someone just super chatted that. Yeah. Yep. Yeah, Squiggles super chatted that a little while ago. Cringe Player says a Bard statement sound like a cope. Yeah, probably is a little cope there, but yeah, like I said, guys, I have a feeling Supreme Court's not gonna, once again, remember expecting the Supreme Court to save the day. Ain't gonna happen. Much I don't want to lie to you guys. Ain't happening, Captain. So, all right, guys, that's been 3 hours. It's been a long 3 hours. A long, hard 3 hours. That's a shame, says, I mean, the First Amendment stuff here is pretty straightforward. Did they even mention Hess? Eminence case from right here in Bloomington? I don't think they did. Nope. J-Bet says, fucking Roberts, it's not going to be the entire Supreme Court. Maybe Alito and maybe Thomas are going to say, no, this needs to be heard. It's going to be, they're going to punt as a majority. So, yeah. So, like I said, can't wait to be wrong, but clip this. I'm probably going to be right. It's not going to be the only state he's probably going to get removed from using this logic. Metal Matt says potentially criminal is greater than Nick Rekieta. Some math I finally agree with. So, Augustin says fat people are defeatists because they lack the willpower to not eat. Well, oh, funny. You're a funny guy, Sully. That's why I'm going to kill you last. So, all right, guys. We're going to wrap this up, but I'll answer this one last question. David Jowers saying, so Colorado has disenfranchised their voters. By the logic they've employed here, you haven't been disenfranchised because you can't vote for ineligible candidates. You can't vote an eligible candidate into office, so therefore you haven't been disenfranchised. And you can write down an ineligible candidate, your vote doesn't count. But that's no different than if you just turn in a blank vote or you throw your ballot away or you don't vote at all. So that's what that would be their argument in response. So Carrie says, no, don't go. I got to go, guys. Mrs. 2.0 made some beautiful, beautiful food I need to go eat. So I need to get that going. Guys, that is it for tonight. Maybe, God, I hope there's not something new tomorrow. We'll be on Thursday and we'll talk more about this. I'm sure there'll be more fallout in the meantime. In that said, just now's not the time for fear. Now's not the time for fear. That comes later. And we'll be able to talk more on Thursday night, guys. So take care. And apparently the Colorado Supreme Court saying because you did it, you are in fact guilty of committing insurrection. So good night, everybody.